Objection. The chair is authorized to declare a recess any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter adopting an amendment for which a recorded vote is ordered. And now recognize the gentleman from Texas, Mr. Nels, to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank the gentleman. Pursuant to notice, I call up H.R. 4638, the BowWow Act, for purpose of markup and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 4638.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. McClintock, for an opening statement.
Thank you, Mr. Chairman. I hope you'll all have a chance to meet Freddie the Beagle, who's, I think, in the anteroom right now. Freddie's a 5-year-old CBP detection dog who serves our country every day, along with his handler agent, Melissa D. Snyder. Freddie was found abandoned as a puppy at the side of a Georgia road. He was adopted into the USDA's Detector Dog Program. He's since conducted over 590,000 searches, resulting in nearly 2,000 seizures of prohibited agricultural products attempting to be brought into the country. These dogs are highly trained to alert if they smell contraband being smuggled across our nation's ports of entry. To them, it's a playtime game, but they're the most efficient and unobtrusive system we have to secure busy airports. Now, on June 24th of this year, Freddie and Melissa were working Dulles International Airport. On that day, Freddie alerted to luggage on a flight coming from Egypt. While Agent Snyder questioned the owner, this man violently kicked Freddie with sufficient force to lift Freddie off the ground. Freddie suffered contusions to his right forward rib area. He was taken off duty for 2 weeks to recover. And there they are, by the way. Be sure to say hi. It turns out this man was smuggling 117 pounds of meat and produce which were prohibited from entering the United States. Well, he pled guilty to harming an animal used in law enforcement. He was deported to Egypt 2 days later. He will never be allowed back in our country again unless, of course, another Joe Biden becomes president. Now, that same month, leftist protesters in Los Angeles physically attacked horses used by the Los Angeles Sheriff's Department for crowd control during an anti-ICE riot. Horses are used extensively by federal agencies for crowd control and also for access to remote areas along the border frequented by human and drug traffickers. So Congressman Calvert brings us this simple bill that says that if you are convicted of harming a law enforcement animal or you admit to doing so, while you are a guest of our country, you will immediately be expelled and never allowed to return. Yes, it is true that we have good laws to punish such animal cruelty, and yes, such assaults can be defined as moral turpitude to bar admission, but that finding can often require Byzantine legal proceedings. They'd eat up valuable time and resources if they're pursued at all. Now, I know that many of our Democratic colleagues support the open border policies of the Biden administration, which encouraged the largest illegal mass migration in history. They admitted the world's most violent criminal gangs and cartels into our communities. They suppressed American workers' wages, and they cost taxpayers an estimated $160 billion a year to support. I know that many are now vigorously, and in some cases violently, opposing the enforcement of our immigration laws under the Trump administration. They can't change these laws, so they seek to obstruct their enforcement and attack and harass and threaten the law enforcement officers who are upholding them. Some Democratic state and local officials have even revived the disgraced doctrine of nullification to defy federal law that we all thought had died with the Confederacy. Now, this is a deep and irreconcilable divide between our parties that only voters can ultimately resolve. But can't we at least all agree that kicking a 5-year-old beagle at an airport should disqualify any foreign national from entering our country ever again? That's the entire one-paragraph law, and I hope we can put aside our political differences and all support it. I yield back.
The gentleman yields back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
And thank you kindly, Mr. Chairman. As co-chair of the Animal Protection Caucus and a huge dog person, I think I counted 7 in our extended family this morning. I've taken a strong interest in this bill, and the case underlying it, the case indeed illustrates the cavalier, violent abuse of animals that's still pervasive in our country, around the world. Alas, the bill is a great example of a trend that I think both sides have tried to resist, which is duplicating existing offenses and simply filling the statute books with redundant provisions. It all started, as the gentleman said, when Canine Detective Freddie the Beagle, who we get to meet today, who was working with Customs and Border Protection, detected smuggled agricultural products at Dulles Airport. Apparently, he repeatedly barked and alerted his commanding officers to the presence of over 100 pounds of prohibited food items in bags unloading in the luggage pickup area. And the prohibited food belonged to Hamed Ramadan Bayoumi Ali Marie, age 70, a traveler and a foreign national visiting from Egypt. So this gentleman, apparently frustrated and angry over the dog's excellent detective work, kicked Freddie so hard he became airborne and suffered bruised ribs. And if you're an animal lover like me, you would exclaim, that should be illegal. And sure enough, it was illegal. Mr. Marie was promptly arrested, held by the police for several days, and then he pled guilty to 1 count of harming animals used in law enforcement under 18 U.S.C. 1368. He was convicted, and he was sentenced to time served by the judge, ordered to pay the veterinarian's bill, which records show was $840. I'm glad to see that Freddie is doing fine. And then he was promptly, Mr. Marie was promptly deported and sent back to Egypt. So, as the case itself demonstrates, the conduct is already criminally proscribed and is the basis for removal of a non-citizen. It's against the law now to kick a police dog, and Mr. Marie won himself 3 days in jail for doing it. But the opportunity to introduce a redundant bill is apparently impossible for us politicians to pass up. H.R. 4638 would render inadmissible and deportable any non-citizen who willfully harms a police dog or a police horse. I'm unaware of any mad rush of immigrants roaming the country and attacking police animals, so I'm not sure what crisis this surplus language is responding to. I don't know if it's about horses being bootstrapped in. I'm sure anyone attacking a horse would also be swept under the current statute. In any event, what should have happened here did happen here. Mr. Marie was criminally charged, prosecuted, convicted, and removed from the country. In other words, the criminal justice system, the immigration system worked just like they're supposed to. A foreign national committed a crime. He was arrested, charged, prosecuted, convicted, and removed, all without being stripped of any of the due process protections that we afford people in America. So all this bill really does is short-circuit the need to actually prosecute someone for an alleged assault. The bill would render not just a vacation traveler, but even a green card holder deportable for kicking a police animal, even if he or she is never arrested, charged, prosecuted, or convicted of the crime. Now think of that. That's what this bill is doing. It is short-circuiting the entire process which took place in this actual case. So there's no crime so serious that people don't actually have to be prosecuted for it before being punished. If a citizen or a green card holder murders someone today, we require that they be convicted prior to being sent to prison or to being rendered deportable. There must be an actual conviction. If this bill were to become law, individuals accused of attacking police animals will be treated in the immigration system more harshly than people accused of murdering a human being. That just makes no sense. And it sticks out like a sore thumb in our statute books. Under the INA, a non-citizen convicted of a crime involving moral turpitude, or CIMT, is automatically deportable. And the gentleman has conceded that this was treated as a crime of moral turpitude and can be treated that way. There are a wide variety of these offenses, including acts to impede law enforcement and to harm animals. The key point here is that only persons who are convicted of such a crime are rendered deportable. This bill eliminates the conviction requirement, which is a very dangerous road for us to go down. And I know that the Homeland Security Secretary Noem, infamously in her book, bragged about killing her dog, but she should not be fired or punished for that with all the protections of due process, even though she wrote about having done it. If she were to be prosecuted for that, that's something that she should actually be brought to court for and not simply say, oh, there's evidence of it, she's admitted it. I urge members to oppose this bill, and I yield back.
Without objection, all of the opening statements will be included in the record. The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I've got an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from California to explain his amendment.
Thank you. This amendment just makes a small technical change to the short title. It doesn't change the substance of the bill, and I yield back.
Gentleman yields back. Who seeks recognition?
I have an amendment at the desk.
Gentleman from New York has an amendment. Gentleman may, the clerk may report.
I reserve report.
Point of order reserved by the gentleman from California.
Amendment to the amendment in the nature of a substitute to H.R. 4638, offered by Mr. Goldman of New York. Page 1, strike lines.
Without objection, the amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Well, let me read it, please, if I may. It's page 1, strike lines 2 through 4, and insert the following. This act may be cited as the Christie Noem Canine Relief Act of 2025. It is noteworthy that we are doubling down on deporting, arresting individuals who assault dogs in this case. And make no mistake, I am strongly against anyone assaulting dogs. And I think the ranking member laid out very clearly the problem with this bill. But I really want to know how, if at all, it would apply to cabinet members who have admitted that they have shot and killed a dog. Is it only at the ports of entry, or is this just broadly against any assault on dogs? Because my understanding from reading the bill is that this would apply to someone who kills a dog. Now, obviously, we're focused here on the deportation of people who kill dogs, and presumably that would not apply to U.S. citizens, although I understand my colleagues on the other side are in many cases trying to denaturalize people. But certainly the Secretary of Homeland Security, as a born American subject to birthright citizenship, would not be able to be denaturalized. So I understand that this bill would not necessarily apply because it is really focused on making sure that we double down and deport not just people who are convicted of killing dogs, but people who have been alleged to have killed dogs. And so this renaming, I think, would really capture the true essence of the bill, which is that we really don't want anybody to kill dogs, especially the Secretary of Homeland Security. And so I would urge my colleagues to support this amendment that would rename the bill the Christie Noem Canine Relief Act of 2025. And I yield back.
Mr. Chairman,
Gentleman yields back. The gentleman from California.
I would insist on my point of order because of the nature of the amendment, but since I've been told that it is technically in order, I would rather say, can I please call the previous question and dispense with this? No?
Can you also, can maybe,
Okay.
can maybe you say
I'll
that you're
strike-
against,
I'd like to
can you
strike-
say you're against the amendment?
I'd like to
Can you do
strike
that?
the last word, Mr. Chairman.
The gentleman's recognized.
Mr. Chairman, the word kill, I'm looking for it in the bill. The word Christie Noem is being injected by the other side. This is about about, in fact, a difference between many of us on the right and many on the left, which is, do people at the time of their request to enter the country or during their stay as visa holders, do they have the same right against being deported that American citizens have? And the answer obviously is no. And I think the gentleman wisely said, citizens are not to be deported. However, a visa or a visa at the port of entry when you're attempting to enter, particularly carrying drugs as this person did, and I only question why he isn't still in jail rather than having been deported.
Ag produce.
Pardon me? Oh, okay. It wasn't drugs. I apologize. But the fact is, this is an example of the difference between the two views. The view that everyone has a right to be here with or without a visa, with or without good conduct. It is clear that this is necessary for the very reason of the argument by my colleague, is he is arguing that somehow, we don't need this law. We need the law if there's ambiguity as to whether or not your entry into the country is at the discretion of the United States government based on your clear living up to the standards for which we have granted that entry. And the standards for granting that entry are higher than just a question of breaking the law. And I think that's the important point, that if you want to say that you have to, as has been said in this committee repeatedly, you have to do egregious things. I remember markups in this committee where we said, if you have been convicted of driving under the influence 100 times, is that enough times to deport you? That was after we did 50 and 25 and 10. We kept increasing it, and at no point could we get a clear agreement that there must be a point at which somebody is a clear and present danger based on driving under the influence or other offenses, and yet we could find no basis for it, only that if it was a violent felony meeting some requirement. With all due respect for today, when they've killed somebody, maimed somebody, or committed a violent felony, but they have done other things indicating their failure to be on good behavior, earlier we have missed the point because we have caused egregious harm to our cities and to our citizens because we waited too long. If you're going to kick a dog because it's simply trying to investigate whether you're carrying contraband and doing the job at a port of entry, then you've already shown that you are not fit to come into our country based on our rules. And for that reason, I oppose any changing of the name that would distract from the obvious goal that the gentleman wrote this bill for, which is to protect the law enforcement people and their service animals from the kind of attacks we saw here. And with that, I would yield back.
Mr. Chairman,
Gentleman yields back. The gentleman from New York is recognized.
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I don't really care about the title of the bill. It's clever to call it the Christie Noam bill because Canine Relief Act, to remind people of how cruel she was to an animal when we're talking about animal cruelty. But the real issue of this bill is not that. The real issue of this bill is that it applies penalties to people who have not been convicted. It says convicted or admitted or various other things, but they have not been convicted. It is fundamental to justice in this country that no one can be punished without being convicted of a crime. There is nothing more fundamental to the liberties of this country than the requirement of conviction of a crime. This bill and several of the other bills on the calendar today do away with that. That is a crime against the Constitution. It's a crime against liberty. We cannot have a society in which people can be convicted of a crime, sentenced to jail or to a fine or whatever, without being convicted, period. That is a fundamental thing in this country. It's been fundamental to English common law before this country. And now we're going to repeal that? That is the core issue of this bill. That's why I oppose the bill, and I yield back.
Gentleman yields back. The gentleman from Florida is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman is recognized.
First of all, it's good to see you all. It's been a long time since we've been together, since we were all furloughed together by the Speaker. And so it's good to be with you. I see trying to get some muscle memory back for you all, see if you have a sense of humor. I want to just set the record straight on a couple of things. We keep referring to Christy Noem's dog as a dog, but actually, it was a puppy. It was 14 months old. And that puppy had a name. Say its name. Cricket. Okay, that puppy had a name. And so if you had a couple moments, I would now like to do a spirited reading from the book by our Secretary of Homeland Security. It starts, I hated that dog. On the way home from a hunt, the dog on the way home from a pheasant hunt was untrainable, and it went to go attack the chickens. And at that moment, I realized I had to put her down. So I grabbed a gun and led Cricket to a gravel pit. Wasn't a pleasant job, but it had to be done. And after it was over, I realized another unpleasant job needed to be done. And so I went and got the family goat and brought that to the gravel pit. And unfortunately, I wasn't able to kill that goat with one shot. So anyway, I think the point of bringing it up is, on the merits of the bill, we can debate the merits of the bill. But if we're just going to get on our high horse about animal cruelty, which I think we all agree on, by the way, I think there's unanimity here on animal cruelty. I just, want to make sure that we apply that universally, and I think that's what the gentleman from New York is just trying to remind our colleagues, who we have not seen in a while, that, the Secretary of Homeland Security also did not treat an animal in which we believe the animal should be treated. And with that, I'll yield if Mr. Raskin has any questions.
Welcome back, Mr. Moskowitz. And first of all, I think your reference to goats is completely immaterial to what we're discussing today. It's not part of the bill. Isn't that right?
There are no goats in the bill. I was meaning, I wanted to, not me, and she wrote this in the book, that after she shot the dog, she's like, that was awesome, go get the goat. So. All
right, well, getting back to the substance of it, whether it's a magnificent dog like Freddie, who joins us today, or Cricket, whose reputation has obviously been besmirched by the Secretary of Homeland Security, all dogs deserve not to be treated in a cruel and capricious way. But the point here is that everything that anybody in this room would have wanted to happen happened in this case. Right after the culprit kicked Freddie, the culprit was apprehended, was arrested, was charged, and spent 3 days in jail before being removed and deported from the country. So one asks, other than the opportunity to say we agree with what happened, what are we doing here? All that's really happening is that the majority is using it as an opportunity to try to dilute this standard that is working perfectly well, which is that if you are actually convicted of such an offense, then you will be immediately removable and deportable from the country. And there's no reason to puncture that basic line, as Mr. Nadler says, in our jurisprudence. And I can't see why any of us would want to go down that road. I thank you for reminding us that animal cruelty is a serious problem across the country, Mr. Moskowitz and Mr. Goldman. And I do hope that we can all agree that what happened in this case is precisely what should have happened. We don't need to be tampering with the law at this point. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Yes, thank you, Mr. Chairman. On this particular amendment, maybe we should amend this amendment to call it the Sri Thandadar bill. And so with that, I think This particular interesting article here is from the UK Daily Mail. Democratic congressman trying to impeach President Trump has been accused of abandoning over 100 dogs to starve after his company cruelly tested pharmaceuticals on them. Sri Thanadar was behind a testing lab that shut down in 2010. Months after the New Jersey lab closed, local animal rights activists alerted authorities to 118 beagles that had been left behind locked in the facility. At the time, the lab's ex-workers told USA Today they had been jumping fences at the facility to provide food and water for the dogs. Insiders claimed that even before the dogs were abandoned to starve, they had lived horrific lives in captivity and were subject to toxicology tests. I don't think they've actually had their paws on the grass. When I walked in here, it looked like they were walking on eggshells. They were kind of afraid to walk on the grass. The point is, and so, Mr. Chairman, I submit for the record this article from UK Daily Mail entitled, "Dim Congressman Sri Thanadar famed for railing against Trump carried out unspeakable act against 118 beagles."
Without objection.
And by the way, California-based organization Defense of Animals then went back to the same site and saved 55 long-tailed macaque monkeys as well. The point is, you're trying to make a joke out of something, and the reality is what happened should not have happened, and when you try to minimize something that's serious, sometimes your humor is not really funny. It's flat. And so if we're going to invoke names here, then I would invoke the name of your own colleague, Sri Thanadar.
Would the gentleman yield?
I'll yield to the gentleman from California.
Perhaps the gentleman would consider modifying his suggestion by adding the name of Anthony Fauci, who's alleged to have presided over the torture of many more beagles and other harmless creatures, all in the name of perverted science.
Will the gentleman yield?
I would be happy to include that amendment. So Mr. Chairman, I'm making an oral amendment to change the title of the article of the underlying bill.
Without objection.
Will the gentleman yield for a question?
No.
Okay. That's totally fine.
I'm going to object to that.
Okay. There's an objection raised to the amendment offered to the amendment. All those in, we can take a roll call on all those in favor.
Who seeks recognition? Who seeks recognition?
But I want. Have you yielded back? Is the gentleman yielded back?
Yeah.
All right. Who seeks recognition? The gentleman from Tennessee seeks recognition. Your gentleman's recognized.
Thank you, Mr. Chair. I am a major animal rights, animal protection legislator for 40 years. I'll have a tie on today with puppy dogs, not because I knew we had this bill, because I like puppy dogs. And Freddie's a great dog. But Mr. Raskin did an excellent job in saying why we don't need this bill. I don't believe my friend Mr. McClintock responded to Mr. Raskin's argument about this being duplicitous. And I think we have a bill that I'm a sponsor of that I think might have been Jim Jordan's bill that said we should go through and eliminate laws in the code that are duplicitous and unnecessary. Mr. McClintock, you're my friend. I have great respect for you. Can you tell me why Mr. Raskin's argument's not dispositive of this bill?
Yes, as I stated in my opening subject, and by the way, Mr. Cohen, I return the compliments. I have a high degree of respect for you, which you well know, and I'm proud to say to all here. And it's very simple. It is correct that it could be interpreted as moral turpitude to have been convicted or to have admitted to such a crime. The problem is that then can trigger a lengthy legal process to determine whether or not that constitutes moral turpitude. And this cuts through all of that red tape and simply says, if you kick a 5-year-old beagle, you're not going to be allowed back in this country. No further legal proceedings are necessary. Now, you do have to either be convicted of that or admit to that. In this case, this foreign national admitted to it. But if he tried to come back in the country, he could trigger a long legal process to determine whether or not that act constituted moral turpitude. This bill makes that legal process unnecessary and simply says, you're not welcome here, go home.
Thank you, Mr. McClintock. Mr. Raskin, you would like to respond?
Thank you, Mr. Cohen. First of all, there is no judicial review of an inadmissibility determination administratively, so it's just false to say that you'd be tied up endlessly in litigation or red tape around that. I mean, I think the facts of this very case, which is the only case that's been advanced by the majority, completely contradict what we just heard, because this all happened within 3 days. So where are the years or months or weeks of litigation and red tape? He was found guilty and he was removed from the country the next day. And he spent 3 days in jail. So he was not, out on the street endangering Cricket or any other dogs at that point.
Thank you, Mr. Raskin. I appreciate the discussion. I'm probably going to vote for this, even though I think Mr. Raskin's discussion is right and it's not necessary, because it's not worth our time. Kumbaya, let's do something for the puppies. Truman said, if you want a friend in Washington, get a dog.
Would the gentleman yield for one moment?
Sure.
Just in a last-ditch effort to dissuade you, because, at first my reaction was yours too, which is, well, this is completely redundant and duplicative as well as duplicitous, as I think you misspoke and said as well. But, why not just let it go? It's not that big a deal. The problem is it sets a very bad precedent now where we're saying we're going to dispense with the necessity of actually trying people for crimes, and we're just going to declare them guilty of the crime, and then they can be removable or deportable, or, in the context of citizens, subject to other kinds of administrative law sanctions. And one would think that the Judiciary Committee of all places in Congress would want to resist that erosion of basic standards. Thanks.
I will reserve my judgment, but I am very much affected, as I'm sure Mr. Roy is, by his contact with Freddie.
Mr. Chairman,
What purpose, gentleman?
I need to strike the last word.
I think you're on the amendment. Go ahead. The gentleman's recognized.
Thank you.
Did you speak on the
Mr.
amendment?
Chairman, I'm
or
not going to repeat the argument that I made, that Mr. Raskin made, that this is a very terrible precedent to set, that we can penalize people without actually convicting them in a court of law. I just want to comment on something I think it was Mr. Biggs said when he was talking about cruelty to animals. And of course, cruelty to animals is terrible. But he used the name of Anthony Fauci. Now, no one has alleged that Anthony Fauci was cruel to animals. Now, true, animals were used in his medical experiments, as always is the case. You don't want to give a new drug to a person without first testing it on animals. That is part of the scientific method. It is absolutely necessary for safety for human beings. Now, Mr. Biggs mentioned someone else, I forget who it was, who he said was cruel to animals. He may well have been. But when he mentioned Anthony Fauci, he was not. He simply used animals in the proper scientific method to protect human beings. And I don't think we want to say that drugs should be tested or medical procedures should be tested first on humans without being tested first on animals. I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Mr. Chairman, I mean, I would just state what we're talking about here is a pretty simple question. If you've got an animal, in this case we're talking about a dog, we're talking about Freddie, in service to our country, and we've got an individual who is here as a guest, port of entry in this question, or it could be now you're talking about in the interior or otherwise, and they kick a dog. They kick this animal. They harm this animal. That we don't believe you should be a guest anymore. That's literally all we're saying. I don't think this is that complicated. Don't be an idiot, or we're going to remove you or not admit you. It's that simple. I yield back.
Gentleman yields back. Gentlelady from California is recognized.
Thank you, Mr. Chair. You know, I didn't get a chance to meet Freddie, but I hope that Freddie is getting some SAG or AFTRA credits for participating in this show today. I do not support this, not because I don't support animals. In fact, I just adopted a dog 2 weeks ago from the shelter. But this really is an attempt to try and legitimize unlawful deportations and using it through the weaponization of Freddie, or, you know, using dogs as pawns because they have a soft spot in our hearts. And I've listened to some of the comments, and we have to just say, let's not pretend that this is about protecting law enforcement, because it's not. If we were really serious about protecting law enforcement, there would have been a larger outcry from my colleagues on the other side of the aisle about pardoning January 6ers who attacked Capitol Police. Last I checked, Capitol Police are members of law enforcement. There'd be less consternation about even putting a plaque up on the wall honoring those Capitol Police officers who so valiantly protected everybody up in this place. If we were really about protecting law enforcement, you would have been against cutting government funding to law enforcement that work with community-based organizations in our districts and cities and states across this country who are working to make the streets safer. If it was really about protecting law enforcement, there would have been a larger outcry about giving settlement money, government money, to folks who actually attacked Capitol Police officers. If it was really about protecting law enforcement, there would be an outcry about why the DOJ is actually taking AUSAs off cases where they and law enforcement have been working on for years to go after cartels and human traffickers. People kidnapping our children and trafficking them and prostituting them. So let's keep it real. This is a charade. It's a charade. I guess we have to get it out of our system. But this is not about protecting law enforcement. And no, Freddie shouldn't have been kicked. No dog shouldn't be kicked. But you know, there should be a larger outcry actually about don't be an idiot, don't kick a dog. How about don't kick your wife? Don't kick a child. Don't molest a child. Don't traffic a child. How about that? No outcry about that. No outcry about that. So I don't know if I would like to yield my time, I guess, to our ranking member. If not, I yield back. Or I can, okay, I yield back.
Gentlelady yields back. The gentleman from for unanimous consent.
Yeah, you see.
Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I enter into the record without unanimous consent. NIH shuts down Beagle Lab after 40 years of taxpayer-funded cruelty. The director of that was Anthony Fauci.
Without objection. Gentleman from California is recognized.
Thank you, Mr. Chairman. The Democrats see no distinction between Kristi Noem's experience with her dog Cricket with the assault of animals that are used by law enforcement. Well, I think they'd have a point if Kristi Noem was a foreign national and she shot a law enforcement dog named Cricket. This would certainly apply to her, but none of those circumstances apply in this case. We understand that many Democrats see no problem in obstructing law enforcement when they're obstructing laws the Democrats don't like or are committed by guests of our country, whether here legally or illegally. The ranking member reminds us that one can be turned away at a point of entry administratively, and that is correct, but that doesn't apply to foreign nationals who've gotten beyond the port of entry. This makes all foreign nationals deportable if they have attacked law enforcement animals. The former ranking member objects that this doesn't require a conviction. Well, actually, it requires either a conviction or an admission of the crime. And in fact, that language is identical to the grounds for inadmissibility for crimes involving not just moral turpitude, but controlled substance offenses under the Immigration Nationality Act. Even for grounds of removability, convictions are not always required. For example, an alien can be removed for overstaying his visa, violating his non-immigrant status or condition of entry, smuggling aliens, committing marriage fraud, being a drug user or drug addict, falsely claiming U.S. citizenship, or engaging in espionage. By requiring at least an admission, this bill conforms to the pattern of other grounds of inadmissibility and removability. Here, the federal crime has clear elements that are straightforward with a criminal provision. And if an alien, like Freddie's attacker, had admitted to such reprehensible conduct, why can't that alien's own admission be used to show that that alien is inadmissible or deportable? I yield back.
Gentleman yields back. The gentlelady from Vermont is recognized.
Thank you, Mr. Chair. Just briefly here. So we're sitting here debating the BowWow Act. And just to be clear, you know, I'm a huge supporter of dogs. I have a dog myself. I have an incorrigible Labradoodle named Wheelie, and I love my dog. But I love my 15-year-old daughter more. And it is so shocking to me that we have not heard from any of the victims of Jeffrey Epstein in this committee, that we have, you know, I'm very happy to meet the dog here. It's actually bringing me some joy seeing the dog here in the committee. We need some joy around here. But again, I want to speak for so many of my constituents who have been so disgusted by the rhetoric that has come out of some MAGA talking heads in the last few weeks around the trafficking that was done, not just by Jeffrey Epstein, but so many well-connected, powerful men. And we have time to debate the BowWow Act in here, and yet we have not made any time to hear directly from this women who have never received any bit of justice. And so again, I think I speak for so many of my constituents. We love our dogs, we love our animals. We have a lot of animals in Vermont. It's a rural area. But my God, we love our kids more. And it's just shocking to me that we spend time on this, on a bill that is not needed to protect animals, that I do believe is a way to legitimize unlawful deportation. We can't seem to find time to give these women a voice here in this committee. I yield back.
Would the gentlelady yield?
Gentlelady yields to the ranking member.
Yeah.
I'm happy to yield to the ranking member.
Thank you, Ms. Ballant. Just to recap where we are to move things along, the bill would make deportable what is already deportable. It would treat as a crime what is already a crime. It takes the superb law enforcement work of Freddie and the human beings he's attached to, the police officers. It celebrates it, and we all celebrate it. They did a great job, and it all worked. The gentlelady makes an excellent point, which is, if we're really in that desperate of search for something to do, why don't we invite the Epstein survivors in here? They're dying to talk to us. They just had a big press conference outside. They want America to hear. They're saying it's time to blow open not just the Epstein case, but all of the cases of sexual abuse of children and young people across America that's been institutionalized in so many places. I mean, if we're really in that much of a hurt to find something to do, let's do that rather than dispense of the conviction requirement. Our friend tells us that this is tied up endlessly in red tape. It takes forever. This guy was held for 3 days and was out of the country. It worked great. The police did a great job. Freddie did a great job. The law is working. So this strikes me as completely unnecessary and somewhat transparent attempt to just pile on to a situation that's already working. There's nothing that advances our freedom in doing that. There's nothing conservative about doing that. If it ain't broke, don't fix it. And this is trying to fix something that's working just fine, as the only case that's been identified vividly demonstrates with the presence of Freddie. So thank you for yielding to the gentlelady, and I yield back.
Ms. Ballant, would you yield?
I will yield.
I just had a thought. The Senate's kind of not in the best of lights these days for trying to give $500,000 or more to 8 senators. Maybe they'll give $500,000 or more to each of the victims of the crimes that they're covering up.
I yield back.
Gentlelady yields back. The gentlelady from Wyoming is recognized.
I voted for that. I voted for the Lake and Riley Act.
Hey, the time belongs to the gentlelady from Wyoming. Time belongs to the gentlelady from Wyoming.
Is about illegal conduct by illegal aliens. I hope that we can remember that's what the purpose of this is. With that, I yield to Mr. Roy.
I would just take a few seconds to note that in response to one of the comments from my colleagues on the other side of the aisle about wanting to focus on the abuse of spouses or abuse of women, that my colleagues on the other side of the aisle were all up in arms about the removal and deportation of Abrego Garcia earlier this year, and Abrego Garcia beat his wife. I yield back to the gentlelady from Wyoming.
Thank you for yielding. I hesitate to get into this thing with regard to Epstein, but I want to introduce for UC an article entitled "Joe Scarborough asked Dem Rep point blank why his party didn't call for Epstein file release sooner."
Without objection.
Yeah, and so for 4 years, it was myself and a handful of Republicans that were asking that the Epstein records be released. For 4 years, we were asking for those. But the Biden administration sat on their hands and did nothing, which is why Joe Scarborough asked, well, why didn't you ask? You had control. You had all 3 levers. You sat on your butts and didn't say anything. Now, I've met with victims of Epstein, and they've come in, and we've heard their testimony. Not in this committee necessarily, but I've heard them in committee. And I just want to remind you that maybe when you're crabbing and fussing and complaining and carrying on, maybe you ought to look in the mirror a little bit. I'll yield back.
I'd also like to note that it was the Democrat delegate from the Virgin Islands that was not only Jeffrey Epstein's mouthpiece during congressional hearings, but was his fixer. So if you want to raise questions about Jeffrey Epstein and who has things to hide, the Democrats, as my colleague from Arizona just stated, perhaps you should look in the mirror. It is one of yours. It is one of yours. It is the Democrats that were the fixers and the attorneys for Jeffrey Epstein. So I guess that it's very difficult for me to take you seriously as you attempt to turn this into yet another attack and another way to get Donald Trump. This isn't about Donald Trump. This is about the Democrats who were aligned with Jeffrey Epstein at the very time that they knew that he was a convicted felon as a pedophile. As a pedophile. So I don't believe your hysteria. I don't trust the way that you try to turn everything into screaming about Jeffrey Epstein, because it is extremely obvious that all you're attempting to do is deflect from your failures and try to cover up the fact that it was the Democrats that enabled
Would the
him.
gentlelady from Wyoming yield?
I will, yes.
Yeah, in this last minute, and I wonder if the gentlelady could confirm whether what I'm about to say is correct, that it was in fact President Trump's administration in 2019 that federally indicted Epstein in July of 2019. that it was in fact the Trump administration, the first term, that was going after Maxwell and set the stage for her indictment. That it was in fact the Trump administration, along with the Oversight Committee led by Republicans, that have released tens of thousands of pages of documents this year via the appropriate path of subpoena and making sure that more information is public. And then in fact, as the gentlelady from Wyoming noted, in a hearing that I was sitting in right next door in Oversight where I was questioning Michael Cohen, literally while I personally was questioning Michael Cohen, we had a Democratic member of that committee that was texting in real time with already convicted pedophile Jeffrey Epstein. Is that correct? I yield back.
You are absolutely correct. I've watched the video. With that, I yield back.
Gentlelady yields back. The question occurs, we can get that in a second. The question occurs on the amendment offered by the gentleman from New York, if I remember who offered that amendment. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chairs, the noes have it. Question now occurs on
Move to strike last word.
okay, well, let me do a UC, then we'll come to you, then ranking member. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. This is another article. Biden administration failed to probe more than 7,300 reports of migrant child trafficking.
Without objection. I'll go to whichever one. You want to go first?
Oh, no, please, the gentleman.
Gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature of a
Without objection, the
substitute.
amendment will be considered as read. The gentlelady is recognized to explain her amendment.
Well, Mr. Chairman, I sure did miss you and your
Good to see you as
excellent
well.
leadership. I had forgotten what critical things we were taking up in this committee. You know, we've entered election season because despite being gone for 7 weeks, I think it is now, the majority is once again trying to distract us from the fact that grocery prices and utility prices across the country are rising, from the fact that this administration has been protecting pedophiles, building gilded ballrooms, sending tens of billions of dollars to bail out Argentina, while refusing to extend Affordable Care Act tax credits for 22 million Americans. And the most often used tool in the Republican playbook is, surprise, blame immigrants. Blame an immigrant. Find a crime, blame an immigrant, make people deportable and inadmissible without requiring a conviction, deny them basic due process, and then just replay that, rinse and repeat, over and over again. But this is a new one even for us moving into the arena of harming animals, and I feel like we're all putting forward our animal creds, so I wish I had a picture of my beautiful 14-year-old Labradoodle, Otis, because he is, for me, part of our family like tens of millions of Americans, and I have been somebody who's championed animal welfare. So I take violence against animals seriously, but so do our immigration laws. That's what happens right now. The crime that's referenced in this bill requires someone to, quote, willfully and maliciously harm a dog or a horse. This is almost certainly already a crime involving moral turpitude, which can and did in this case render someone deportable or inadmissible from the country. In 2018, the Board of Immigration Appeals made clear that the crime of animal fighting is a crime involving moral turpitude, and that is because there is a clear intent to harm the animal. So the issue is already well covered under our immigration laws, and this bill is not necessary. Now, unnecessary bills alone are not a reason to vote no, but this bill goes further than that. Under current law, a person does not need to be convicted of a crime to be inadmissible. However, under most circumstances, you do need a conviction to be deportable. And when we talk about all the red tape, it seems to me like that's being used as an excuse to just get rid of due process. It takes too long, therefore we're not going to have due process. But once again, this bill, as has been done with so many other bills that we've been voting on in this committee, Republicans don't require someone to be convicted of the crime to be deportable from the country. That means that a green card holder who has lived here for a generation or more could be deported from the country without even being convicted of a crime. The bill was written in response to this incident where a 70-year-old man kicked a poor Customs and Border Protection agriculture detector dog at Dulles Airport. The incident was horrible. The dog was just doing his job. But that man has been pointed out over and over again in this committee, was tried and convicted in federal court in a very short period of time, removed from the country. And so my amendment is, at minimum, what needs to be done is change the deportability section to require a conviction. That's what this amendment does, to require a conviction in order for the person to be removed from the country. It has never been more important for people to have their day in court. Just look at what is happening across the country as federal immigration authorities, led by Gregory Bovino, the head of CBP, inflict terror on American communities. We've seen residential communities tear gassed without a care for the very young children who have been affected. We've seen a daycare teacher with work authorization arrested at a school, inflicting irreversible damage on all the kids that she cares for. We've seen U.S. citizens brutalized by ICE and Border Patrol. The right to being innocent until proven guilty should be something that every single one of us in this committee can agree to, and a bedrock principle of fairness, due process, and the rule of law. But unfortunately, apparently, when it comes to immigrants and the people who love and support them, this administration and this committee doesn't seem to care about fairness, about due process, about the rule of law. Because under the Trump administration, federal agents have falsely accused Venezuelan soccer players, bakers, makeup artists of being Tren de Aragua members. They've attempted to deport someone for writing an op-ed, arrested U.S. citizens, falsely injured peaceful protesters, including pastors and people of faith. So we need to get back to the basics and protect the fundamental due process rights of everyone as the Constitution requires. Hope I can count on my colleagues to support this amendment. I yield back.
Mr. Chairman.
Gentlelady yields back. Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. Once again, I think of that word hypocrisy, and my good friend, Mr. Biggs, and a few others have brought it up. So let's just go through this step by step. We have to bring the Epstein case into everything. That's okay. It is a big deal. What happened to those children and those young people was god-awful. The part I don't understand and nobody can explain to me is that my good friends on the other side keep acting as if they are the protectors of children or the protectors of these children. But the reality is that in year one of Biden's administration, they didn't do anything. Okay. But in year two, they didn't do anything. And in year three, they didn't do anything. And in year four, they didn't do anything. So if this was such a big paramount issue, if this is something they cared about so much, that bothered them so much, that hurt them so much, that attacked their moral sensibilities so much, why didn't they do anything when they had the ability and had control of it all? It begs that question. I think we know what the answer is. So I would ask that they stop it. There are good people on both sides of the aisle that are extremely concerned about this. I, for one, I'm a sponsor of the bill to release the information from Jumpstart, many others as well. But don't take that moral, righteous path that you are above it and you are fighting for them because you weren't there for years, not for days, not for weeks, not for months, for years. Nothing happened. Secondly, animal abuse is never a good thing. And as somebody who at the state legislature, in the state senate, and the state assembly for years that I was there, written a lot of laws dealing with it, you can tell what an individual is about very often by the way they treat children, the way that they treat their elderly, and the way they treat animals, defenseless animals. And quite frankly, when an illegal person hurts an animal, yes, they should be deported. Now, some folks are maintaining that is already the case, and it's not clear, and it's ambiguous, and even Ms. Jayapal, who is very knowledgeable, said, well, almost certainly it's covered already. Well, almost certainly isn't good enough for me. Almost certainly doesn't mean certainly. It doesn't mean definitely. It doesn't mean that it absolutely is covered. So we just want to make sure if you're here illegally, and particularly if you're a bad person and a criminal to boot, you already should be deported. But if you hurt an animal beside all that, we have enough problems, quite frankly, with our own people that were born in the United States of America who were animal abusers. We don't need to illegally import them from other countries. Almost certainly isn't good enough. Let's make sure. What harm does it do, for God's sake? And then finally, it was said that we're always blaming illegal immigrants. No, we're not. We love immigrants. I'm going to go through this again. Immigrants, most of us were, our families were, our families throughout history have always brought people here. That's a good thing. It refreshes and renews America and makes us stronger. But we don't need illegal immigrants, particularly those people who are lawbreakers, even worse. They don't belong in America. Again, we have enough of our own problems and issues in America that we don't have to bring in all the issues and problems from around the world. So I know as many times as they keep saying we're blaming immigrants, I'm going to keep saying, no, we're not. We're blaming people that are on the terror watch list, or people who have committed crimes, or people who are moving drugs, or people who are part of cartels, or people who are part of gangs. Yeah, we're against them. We don't want them in America. Be mad at us. We'll stand for that any day of the week because it's the right thing to do. And with that, I'm going to call you Mr. Speaker. With that, Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Maryland is recognized. Ranking member.
And thank you kindly, Mr. Chairman. I want to try to respond to my friend from New Jersey, both about his meditations on the Epstein case and also about the gentlelady from Washington's amendment. It seems like some of the comments of my colleagues over on this side have struck a nerve, because a lot of your colleagues, Mr. Chairman, are acting very defensive about the whole Epstein thing. And rather than talking about the survivors, the victims, this billion-dollar global child sex trafficking ring, they want to talk about Democrats. So indulge me for a moment while I try to respond to my friend from New Jersey again, because I think we went through this before we went on our 7 or 8 week Speaker Johnson ordered vacation, paid vacation, and I had even provided him the document supporting what I was saying. But Mr. Van Drew is asking what Democrats did, saying, well, our hands are not clean either. We want to simply pose as protectors of children. We're not really interested in stopping child sex abuse. We just want to strike the pose of that. Well, that's a fairly serious charge. One of the things that I offered to my friend from New Jersey before we left was all of the materials relating to a hearing that I called as the chair of the Subcommittee on Civil Rights and Civil Liberties on the Oversight Committee, along with Chairman Cummings, in July of 2019, about Alex Acosta, who was the U.S. Attorney in the Southern District of Florida, who later became Donald Trump's Secretary of Labor. And we sent him a letter. This hearing will examine your actions as U.S. Attorney for the Southern District of Florida in authorizing a non-prosecution agreement for Jeffrey Epstein, as well as the finding by a federal court that you violated the Crime Victims' Rights Act by keeping this non-prosecution agreement secret from the many victims of Mr. Epstein's crimes. Your testimony is critical, and so on. We had an entire hearing on this. So to the charge that somehow we weren't interested and we weren't doing anything, I say false. It has been debunked, and Mr. Van Drew, if you'd like, I can give you the exact same documents I gave you before, if you'd like. Now, let me say this about the Biden administration. I'll yield to you as soon as I have a moment, Mr. Van Drew. It wasn't until Donald Trump that we associated what the Department of Justice did with the president who was in office. We considered the Department of Justice an independent law enforcement branch, and yet nonetheless, we see imputed to Joe Biden what is the reality under Donald Trump, which is he makes all the calls there. I mean, he literally tells them, oh, I want you to go out and investigate Bill Clinton now, or Larry Summers now, just investigate the Democrats, and they do it. And our colleagues who are on the Judiciary Committee of the U.S. House of Representatives don't say a word about it. That's astounding to me. But in any event, okay, you want to view it your way? Let's view it your way. What happened under the Biden Justice Department, under President Biden? In 2021, they prosecuted Ghislaine Maxwell. They successfully prosecuted her, and she was convicted, and in the courtroom of Judge Allie Nathan of the Southern District of New York, she was sentenced to 20 years in prison for engaging in human trafficking, child sex trafficking, solicitation, procurement across state lines, and so on. That was under the Biden Justice Department. So to Mr. Van Drew's claim President Biden didn't do anything, if you want to attribute what happened at DOJ under him to him, he certainly did do something. They convicted Ghislaine Maxwell. Then she engaged in a whole appeals process. The gentleman will remember in 2022, the Department of Justice fought that for an entire year and continued to fight it even while they continued the investigation. Well, then what did your guy do? He got into office and they summoned all the prosecutors, all the investigative files, and they killed the investigation. Despite the fact that this is a more than $1 billion international child sex trafficking conspiracy. They killed the investigation. Nothing to see here. You guys were here when Kash Patel showed up and he said, oh, well, there was nobody else implicated. Nobody else implicated with more than 1,000 victims, hundreds and hundreds of victims. These people going there, exploiting and abusing these girls and these young women, 4 banks filing suspicious activity reports after the death of Jeffrey Epstein. Afterwards, they decide to file these, saying there were more than $1 billion. Yes, I'll yield to my friend.
Just a quick point of clarification. Do you know when the Maxwell case was indicted? Was that Biden or Trump?
It was under Trump. Again, I'd like to view the Department of Justice as an independent law enforcement entity. So yes, that was pointed out before. He was
it needs to be. May I have one more question?
The time of the gentleman has expired. I can yield to you for a question that you can yield then to Mr. Raskin. So I'll recognize the gentleman's time has expired. He yields back. Gentleman from North Carolina is recognized.
Mr. Raskin, I'm going to ask you a question. Just
Please.
In terms of this whole mantra, one of the concerns that I've vocalized to you is the need to protect truly innocent people in this disclosure, in this effort. And I welcome your acumen and your insights. Is it possible to have a mechanism where people who are truly bystanders, the little men, the little women in New York, in Florida, wherever, to prevent them from being released and forever tarnished in this effort? And I welcome any insights you have.
No, and I thank you for the seriousness of your question and also for your great experience as a real prosecutor. As I understand the Oversight Committee's subpoena and what the chair has worked out with Mr. Garcia, that names of victims will be redacted. So clearly they've got the power to do that. There are other names that have already come forward, Lauren Summers or Bill Clinton. Presumably they can take care of themselves. Mr. Summers has already said he's deeply ashamed, and he ought to be deeply ashamed of his relationship with Jeffrey Epstein. These are the kinds of things that should have come out a long time ago. But I'm with you. You know, you are somebody who should be involved because of your many years as a prosecutor in seeing to it that people are truly innocent whose names just show up.
Sometimes the best criminals are the hardest to catch, and they embed themselves with innocent people to make it hard to catch. And in this investigation, over the number of years, I'm worried about the waiter, the waitress, the bellman, the cab driver, the chauffeur, whoever it may be. And if we just willy-nilly release all the files, those are the people that I'm most concerned about. Larry Summers can defend himself. But it's the people who are 20, 25, 30 that don't have the resources of a Larry Summers that I'm...
And I hear you. I believe the Massey Kana bill includes such protections. I'll find the language for you in there.
Well, there is one concerning piece there that says social embarrassment is not a reason to withhold the information. And I get the spirit behind that language, but in my opinion, it's way too broad, because if there is someone who's innocent, they would not only be embarrassed, they'd be forever tarnished. And I believe that would be a reason to withhold those names. And again, I would love to talk about a mechanism to do that at some point.
I'm happy to look at the language with you to see that it's
Would the gentleman from North Carolina yield?
Yes, I will yield to Mr. Roy.
Yeah, I just want to echo the sentiments. And the gentleman from North Carolina, I've been having this conversation over time about our wish and desire to be able to amend language or be able to tweak it in order to ensure that that safeguard is in place, because I too have the same concern that it could be overbroad in terms of what it might mean for an innocent individual. And I would just note that, and I mean this respectfully, because I think that was a good back and forth and agreement, that the ranking member used an example out of the Oversight Committee in terms of redactions. I agree. I do think that there was a lot of good faith effort, there to do that the appropriate way. But we're talking about here, Congress is now statutorily, we're coming out and we're saying do X, right? We're going inserting ourselves into the prosecutorial function. For all of the politics aside, our general agreement that we want the maximum transparency, but then that raises questions, right? We're not sticking ourselves into the prosecutorial function for every case. There are tens of thousands of cases right now for the Department of Justice in every United States Attorney's Office. We're doing it for this one because of the egregious crimes and because of the political nature of it. But that raises questions of Congress saying, hey, release X, and then what happens? What happens with grand jury secrecy? What happens with victims that might be the innocent bystanders that the gentleman from North Carolina raises? So I would hope that in our conversations, we would, knowing that this is likely going to be voted off the floor this afternoon, that we're having those conversations and directing, hopefully, the Senate to at least address those concerns in a thoughtful and hopefully bipartisan way, because I would hope we all agree we would not want that to occur for the truly innocent individual that might be affected by it. I yield back to the gentleman from North Carolina.
Mr. Raskin, do you want to say something?
I don't even remember whose time it is
It's
anymore.
the gentleman from North Carolina.
No, again, just to say, look, the reason that the victims are in town is because there's been such a massive cover-up for so long that they want to see that the government is going to come clean and that we're on their side. The point you raise is a significant point about the rule of law, and we should figure out a way to embody it in there if the existing protections in the legislative language are not sufficient.
Thank you.
Yeah.
I yield to Mr. Van Drew.
Thank the gentleman from North Carolina. Real quickly, I understand the ranking member's point, but being concerned about a plea deal, and Alex Acosta is far from revealing the thousands of pages, the thousands of people that may have not been involved, and I don't mean the innocent ones. None of that was done. Let's not conflate those two issues. You had one subcommittee hearing and one issue that was relatively minor compared to what this whole huge issue is and is about. I yield back to the gentleman.
I yield back.
The gentleman yields back. Gentlelady from, I think, Pennsylvania was first, then we'll go to the gentlelady from Texas. We don't have someone on our side. Gentlelady's recognized.
Thank you. I mean, talk about conflating the issues. There is an outstanding subpoena from the Oversight Committee, which has not been complied with the White House. We don't have to have a vote. The White House could release the Epstein files today if it chose to, instead of engaging in a White House cover-up. But I think, Mr. Raskin, you had some further remarks, so I'll yield to you.
Thank you for yielding, Ms. Scanlon. Just to complete that chronology, and then I do want to say something about the gentlelady from Washington's amendment. When the Trump administration entered this year, they collected all of the files, all of the information, and all of the existing investigations, and they killed them. They said it's over. And so when the president said the other day, well, I want the Department of Justice to reopen the investigation into certain Democrats, into Clinton and Summers and so on. Of course, he was countermanding his own order, which said there was nothing to see there, but now he's saying, oh, there's something to see there, but I'm going to apply this utterly unconstitutional partisan lens to it and say, I just want an investigation of the Democrats, which, by the way, is something he shouldn't necessarily wish for, because he was a Democrat during that period, shamefully, for that decade-long period when he was best friends with Jeffrey Epstein, and a lot of this was taking place. In any event, let's go to the gentlelady's amendment, which makes all the sense in the world. All she's saying is if we're going to pass Freddie's bill, but let's restore the criminal conviction requirement. I asked my staff to pull for me if they would, and of course they got it immediately. All of the offenses that require a conviction before deportation from the country, okay? And I don't even know if I've got time to go through all of them. It's basically, A to Z, attempt to commit an aggravated felony, alien smuggling, bribery of a witness, burglary, child pornography, commercial bribery, conspiracy to commit an aggravated felony, counterfeiting, crime of violence, destructive devices, drug offenses, failure to appear, and so on and so forth. Okay, so you asked the question, well, what's the big deal? Yeah, we know it's redundant. They already got They already got Freddie's kicker, and he was deported and spent 3 days in jail. We already took care of that. He had to pay his fine. But what's the big deal? We want to have, a piece of legislation in Freddie's name. The problem is that are you going to pull the rug out from beneath dozens of these criminal offenses where a conviction is required? Do we really want to start letting unelected government bureaucrats, people in the executive branch, just describe somebody as a kicker or a terrorist or a drug smuggler? We're going to be dealing with a lot of legislation like that. This is the Judiciary Committee. We are the people who should be focused on due process, right? Everybody has a right to due process. For some people, due process isn't even enough. I mean, you think about President Trump, who has dozens of criminal felonies to his name now after he was arrested, well, not arrested, but charged, indicted, prosecuted, convicted. He had the presumption of innocence. He had unanimous grand jury requirement. He had the right to cross-examine witnesses. He had the full panoply of due process protections. And still he says he wasn't treated fairly. How about somebody who you're going to dispense with all of the due process requirements and somebody's just going to say they're guilty? Or we think you admitted it because the way you responded to our question. I mean, come on. Let's not think so short-term and in such a partisan way. Let's think about the rules of the game that we want going forward. So I'm definitely voting no. I hope all of our colleagues who are interested in due process will not get us on this slippery slope. And I thank my friend from Pennsylvania for yielding, and I yield back to you. Ms. Scanlon, I yield back to you.
Thank you, and I would yield back.
Gentlelady yields back. The gentleman from California is recognized. And we'll come to
Thank you, Mr. Chairman. That's the whole point of the bill. If they deny the charge, that's a whole other matter. If they deny the charge, then this bill wouldn't apply. It only applies to the individual who's already admitted to the offense. The gentle lady, I think correctly, states the effect of this bill. A green card holder who's been here for years can be deported under this bill if they've admitted to assaulting a law enforcement animal. That's the whole point. Without this law, that same green card holder, again, a guest in this country, could remain in the United States indefinitely while litigating whether or not that act constituted an act of moral turpitude. What the gentlelady proposes is that even if the alien has admitted or even boasted of kicking a law enforcement animal, they can remain here indefinitely while arguing whether or not that constitutes a crime of moral turpitude for them to be removed from the country. The gentlelady says, well, don't worry. This will almost certainly be held grounds for removal eventually. It's that qualifier, almost. That's the problem. Kicking a beagle shouldn't almost certainly be removable. It should be certainly removable if that beagle is acting in a law enforcement capacity. Yes, in this case, Freddie's attacker was stopped at a port of entry. He was quickly ejected, but here's the problem. If he then crosses the border illegally, takes up illegal residency, applies for asylum, he cannot be deported until a potentially lengthy and expensive court process to determine whether or not that act that he's already admitted to meets the legal standard of moral turpitude. And that's what this bill fixes. If you've already admitted to this act and you're a guest in our country to begin with, well, you can't come back, and if you do, you can't stay. Yield back.
Well said. The gentleman yields back. The gentlelady from Texas is recognized.
Thank you so much. I just love that we care so much more about dogs' lives than we do actual lives, but I'm going to continue on. I want to make sure that I enter this UC, which is one of the reasons that we are a bit skeptical of any immigration, quote unquote, enforcement laws that y'all are trying to pass. This UC is from The Guardian. It says, immigrants with no criminal record now largest group in ICE detention. You know, I listened to Mr. Van Drew.
Without objection.
Thank you so much. I listened to Mr. Van Drew, who I do respect. And he went on and on and on about how this is about the bad guys. And I will be honest with you and tell you that when it came down to the election, there were a lot of people who really believed that the Republicans and the president were all about getting the bad guys out. People truly believed your words, but your actions are not matching up. Because I've got the receipts showing that they are not matching up. And so call us a little paranoid in believing that the hypocrisy may continue to come from across the aisle. Speaking of hypocrisy, I do want to point out, since we're talking about Jeffrey Epstein, because we couldn't talk about Epstein before. If y'all recall, we were gone for about 2 months because we couldn't talk about Jeffrey Epstein. And now everybody wants to act as if they want to have like a real honest conversation about the victims and the survivors and everybody else. Where was this conversation a long time ago? And I know that y'all love to go back and say that Joe Biden didn't do it. You know, Joe Biden is blamed for everything. Joe Biden didn't do anything and it was Joe Biden's fault. And why wasn't Joe Biden? Joe Biden didn't campaign on it. I just want to be clear. If y'all can run me the tape, then run me the tape. But you know, when you campaign and you go out and you make a promise, then we evaluate whether or not you actually meet your promises. So listen, this was rope that y'all decided to hang yourselves with because the president campaigned on the Epstein files while we were campaigning on things such as affordability. We were campaigning on the things that now people are complaining about, right? Because of the tariffs and the fact that you guys won't say anything and tell the president, hey, sir, tariffs are taxes. We as Republicans, we usually don't like taxes. And guess what? That's gonna make everything unaffordable. So now he's gonna be our big savior and he is gonna reduce the price of foods because he is the guy that actually increased the price of foods. So listen, if you can have this honest conversation about Epstein now, let's just go ahead with this lame duck president and be honest about everything that the American people care about. They care about affordability. They care about the fact that literally people are starving in this country because we have 42 million people, and I don't remember any one of you during that almost 2-month break deciding to go on faux news or any other news outlet and say, you know what, it is wrong to have 42 million people that are relying on $6 a day to eat, and we have the money because somehow our president was able to find under the couch cushion, the one that JD wasn't sitting on, under the couch cushion, he was able to find 40, how much did he find to send to Argentina? 40, there we go, 40 billion to send to Argentina. But those emergency funds, he couldn't find them emergency funds so that Americans could eat. So listen, if y'all are gonna be honest and talk about Epstein right now, let's be honest about everything that is causing y'all to lose real bad. Did y'all see the election results on November 4th? It didn't go very well. So let's just start having honest conversations so that hopefully some of y'all in some of these tight seats, maybe y'all can get reelected and we can just work together.
Ms. Crockett. Would the gentlelady yield?
Who, what, both of y'all want? Y'all want some action? I'll go to Texas first.
You know,
make it fast, Lance.
I want to just thank you for admitting that all of our problems are Joe Biden's fault. It's nice to hear you say that. I'll also remind everyone we're still on the original bill about the dogs, and I'd like for us to stay on topic because, you know, Ms. Crockett, you may be all bark and no bite, but we're not going to roll over. And Ms. Jayapal thinks that we're going to lie down while Mr. Moskowitz goes and fetches amendments. But I hope that she'll put this amendment down because that dog won't hunt, and I'll yield back.
Will the gentlelady yield for a question?
I was going to
I mean, that's quite something. That's quite something. Listen, you know, let's be clear that the only reason people want to have the Epstein conversation today is because 2 days ago, your boss, the guy in the White House without whom you don't do anything, told you that he was going to lose on this vote, and so all of a sudden he released you all to vote for it and talk about it. Give me a break. Like, let's be real. I have a unanimous consent request to enter into the record, Mr. Chairman. Homeland Security missions falter and focus on deportations. Under President Trump, an agency intended to keep Americans safe has diverted resources from combating child abuse, trafficking, and terrorism.
Without
That's what we should be focusing on, not this.
Without objection.
Yield back.
And I don't know if those were dad jokes or dog jokes. I don't know. It was like
I think those
kind of both.
I think they were
both.
downloaded
They were
from the
both.
internet or something.
They were good.
Yeah.
It was a good attempt.
Okay.
It was a good attempt.
Which side? We're on this side. The question occurs on the amendment offered by the gentlelady from Washington. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed
Can we have a
to.
recorded vote, please? Yeah.
The ranking member requesting a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Hunt votes no. Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Ms. Crockett? Ms. Crockett votes aye. Mr. Nels votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Chairman, there are 13 ayes and 17 noes.
The amendment is not agreed to. The question now is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it, and the bill is ordered reported favorably to the House. Members will have.
Could I have a recorded vote, please, Mr. Chairman?
You're supposed to say that before I read that
I'm
whole
sorry.
paragraph. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Issa?
Yes.
Mr. Issa votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Hunt votes aye. Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Gill? Mr. Gill votes yes. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Crockett votes no. Mr. Nels votes yes.
Clerk will report.
Mr. Chairman, there are 18 ayes and 12 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes pursuant to notice. I call up H.R. 6048, the NDO Fairness Act, for purpose of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 6048.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Chairman. I'm proud to partner with my colleague on the other side of the aisle, Congressman Nadler, once again, in introducing the NDO Fairness Act. This bill makes much-needed changes to the way law enforcement obtains the use of non-disclosure orders, also known as secrecy orders. The evolution of cloud computing has significantly changed the way we retain and store personal information. Before cloud computing, the Fourth Amendment required law enforcement to execute a search warrant and subpoena the items they wished to view. The officer executing the search would leave behind a copy of the warrant and an inventory of the property seized. Congress altered this process in 2001, with passage of the U.S. Patriot Act, allowing law enforcement to execute an unannounced search, provided that no property was seized. This process, known as the sneak and peek, required the same probable cause standard as the Fourth Amendment search, but required the party affected by the search to be notified within 30 days rather than immediately after the search. However, in law enforcement wishes to search emails, files, and other data stored on the cloud, the officer never has to give notice to the individual. Instead, they serve the subpoena to the cloud computing company along with a non-disclosure order, or NDO, prohibiting the company from notifying the individual of the search. All, I might add, without prior review by the courts. This has led to an abuse of secrecy orders whereby companies like Microsoft, Facebook, and Google receive thousands of boilerplate secrecy orders per year that are unsupported by any legal or factual basis. And you don't have to look much further than what we just saw with the recent revelations by this committee that former special counsel Jack Smith sought and obtained non-disclosure orders to prevent phone carriers from notifying members of Congress that their phone records had been searched. For more than a year, members of Congress were unable to be notified that their information was searched, all because the federal judge accepted the government's boilerplate secrecy order, suggesting disclosure would seriously jeopardize an ongoing investigation. Regardless of your politics, this should alarm every sitting member of Congress. The NDO Fairness Act will make needed changes to the secrecy order process by eliminating the boilerplate orders used by law enforcement. Rather than a blind assertion that the disclosure would seriously jeopardize the investigation, the court must certify that disclosing the search is likely to result in the destruction of evidence or endanger the life of an individual. NDO Fairness Act would also impose a limit on the length of the secrecy order, something that does not currently exist in statute. Our bill ends indefinite secrecy orders and imposes a 90-day limit, with an extension available if, and only if, the need for secrecy is justified beyond the facts and approval by a judge. This brings the NDO approval process in line with sneak and peek searches. Finally, our bill allows the individual subject to search to request a copy of the information that was disclosed. These changes, I believe, will be more closely aligned with searches of the virtual data and with searches of physical offices, while protecting user privacy in the process. In closing, I'll just remind my colleagues that this bill, it did pass the House nearly unanimously in the previous two Congresses. So I would urge for the swift passage of this bill, and I would yield back.
Exactly.
Chair, the gentleman yields back. The chair now recognizes the ranking member for a statement.
And thank you very much, Mr. Chairman. I want to salute Mr. Fitzgerald and Mr. Nadler for their unswerving devotion to this bill, whose passage is more timely than ever. This committee is, of course, at its strongest, Mr. Chairman, when we work together across the aisle to safeguard American civil liberties, civil rights, and privacy. And I'm pleased that that's exactly what's happening with this bill, the NDO Fairness Act today. Under the Stored Communications Act, the government can ask a grand jury for a subpoena to search the information that Americans store with third-party providers, including email, private messages, work documents, and phone records. This authority relates to non-content information, metadata, essentially the kind of information that you find on your phone bill, and not the actual substance or content of a communication. Unlike with searches pursuant to a warrant, where the government has an obligation to provide notice to the person whose property is being searched, the Stored Communications Act allows prosecutors to seek a non-disclosure order from a federal judge, preventing the service provider from ever telling you that your email account or your phone records were actually searched. There are good reasons why prosecutors might need or want such an order. In some cases, immediate notice might put an undercover agent in danger or risk the destruction of evidence or compromise an ongoing investigation. But 40 years after passage of this act, the government's use of non-disclosure orders has expanded far beyond these emergency cases. Under current law, the request has become little more than a perfunctory box-checking exercise. The statute allows the government to maintain these NDOs indefinitely. Under current DOJ policy, which at least attempts to curb the practice by placing some limit on the duration, you're still unlikely to receive notice of the government search of your records from your phone company or email provider for 3 years after it started. Better rules are needed by limiting non-disclosure orders to 90 days with the possibility of renewal. The NDO Fairness Act ends forever NDOs where non-disclosure orders have no end date. By requiring prosecutors to explain the actual rationale for the request, we end rubber stamp NDOs in which applications are submitted with boilerplate language and no evidence demonstrating any real need is ever adduced. And by ensuring that judges apply a strict scrutiny standard, we limit non-disclosure orders to those where secrecy is actually necessary. In this way, the NDO Fairness Act will protect all Americans who keep an increasingly large percentage of our information online, and we should know if the government is rifling our records, as the chairman has repeatedly said. Although the NDO Fairness Act has been a good idea for a long time when these gentlemen brought it forward, we are obviously moving this bill today in response to the $1 million bonanza jackpot provision for lucky senators that appeared in the funding legislation passed last week. All of this goes back to 2022 when Attorney General Garland appointed Jack Smith special counsel to investigate President Trump's campaign to overturn the results of the 2020 election, a campaign that culminated in the attack on the Capitol on January 6, 2021. In the days before the attack, while the mob was still rampaging in the Capitol, President Trump and some of his associates placed a series of phone calls to members of Congress to convince them to stop the proceedings and not to certify the election, even as the insurrectionists were violently tearing through the building and driving us out of our chambers. As part of his investigation, Special Counsel Smith asked a grand jury to subpoena the phone companies for the records associated with 8 GOP senators and 1 Republican representative known to have been in contact with the White House during this period. The subpoenas sought call records, the kind of information you find on your phone bill with calls made and calls received. He also asked the judge to issue a non-disclosure order for the subpoenas. He did so only after getting permission from the Public Integrity Section and in full compliance with the law and DOJ policy. In other words, they were treated exactly like every other American is treated in similar circumstances. It turns out that the senators learned from the Volume 1 of the Smith Report that their records had been subpoenaed, and they didn't like it. So rather than trying to change the law, adopting this legislation, or improving everybody's civil liberties and everybody's privacy, they instead wrote themselves a little sweetheart provision to give themselves the right to get a $500,000 payoff for the original grand jury subpoena and another $500,000 for the non-disclosure order. And that's just for one piece of technology, like say a campaign phone, that's $1 million. And then for a personal phone, that's another $1 million, and so on. Now, I can understand the objection to having the Department of Justice rifling through your phone records or your email records, and I can understand the objection to the NDOs that subjected these reports to secrecy. But it's something we should deal with for all Americans and not cut a special deal just for senators. It doesn't even apply to members of the House or governors or mayors, but we're not engaged in special pleading. We want to legislate in the interest of all Americans, and so I applaud the efforts of my colleagues on both sides of the aisle to actually do this in this legislation, and I thank them for their leadership. I look forward to voting yes, and I hope it is a unanimous endorsement by the committee. Yield back to you, Mr. Chairman.
Gentleman yields back. Who seeks recognition? Oh, I'm sorry, that's that. Without objection, all of the opening statements will be included in the record. We have to do the amendment in the nature of a substitute. The chair now recognizes the gentleman from Wisconsin to offer that amendment in the nature of a substitute.
Yeah, Mr. Chairman, I do have an amendment at the desk. This is an amendment that simply adds the year to the title. It in no way alters the integrity or the purpose of the bill.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of substitute will be considered as read and shall be considered base text for the purpose of amendment. Now, who seeks recognition? The gentleman from New York. Yeah.
I move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. The NDO Fairness Act is a simple, straightforward, and bipartisan bill that addresses a narrow problem. By establishing essential guardrails for when the government seeks to access someone's electronic communications without that person's knowledge, this legislation would insert balance into a system that for too long has been a free-for-all for government prosecutors. Under current law, after the government obtains a court's permission under the Stored Communications Act to search the contents of a person's electronic communications, prosecutors must then compel the email service provider to produce the relevant data. To avoid having the service provider turn around and tell its customers about the search, the government can also ask the court to grant a non-disclosure order, or NDO, colloquially referred to as a secrecy or gag order. When the order is granted, the provider, be it Apple, Google, Microsoft, or a similar company, is unable to inform anyone of the search, even a company attorney in the case of corporate clients. There is no time limit to these orders. There is no standard to meet. Today, all the government needs to do is cite 1 of 5 potential adverse effects without showing that it is necessary. And the court may grant the request. In the absence of basic rules of the road, prosecutors frequently take advantage of the rubber stamp approval process to acquire NDOs in cases not contemplated by the underlying statute. This includes cases where there is clearly no need for secrecy, such as where a physical search has already occurred, cases where the search is being done on a victim's communications, and cases where the gag order is placed on an institution not suspected of wrongdoing. In all the situations I just described, prosecutors have no cognizable reason under the law to acquire an NDO, yet they frequently do it anyway. These delays don't simply inconvenience the subject of a search, and the negative impacts are not limited to the theoretical or ideological. NDOs are being used to win cases. Rather than providing Americans with meaningful notice that their private electronic records are being accessed in a criminal investigation, the Department of Justice has too often hidden behind its ability to ask third-party providers directly. This denies American citizens, companies, institutions their basic day in court, and instead allows the department to gather its evidence entirely in secret. To be clear, this has been a problem across both Democratic and Republican administrations. This is not a new phenomenon, and addressing it does not require $500,000 payments to a few affected senators. It requires a change in the law. This legislation would do exactly that. The NDO Fairness Act would ensure that gag order requests are only granted in cases where there is no less restrictive alternative and where the court finds that the notification will likely result in endangering the safety of an individual, flight from prosecution, destruction of evidence, intimidation of witnesses, or otherwise jeopardize an investigation. It would also place strict time limits on how long an NDO may be in effect. Finally, by setting a strict scrutiny standard requiring written decisions based on specific and articulable facts, and establishing standing for providers, the NDO Fairness Act would cut down on the number of rubber stamp NDOs. With advancements in technology and the related surge in electronic correspondence, federal prosecutors have increasingly relied on the Stored Communications Act and the archaic protections built into that law to search emails. There are many people who follow this issue closely who are concerned about government abuse of the Stored Communications Act more broadly. I am one of them. But those are bigger fights for another day. What we are doing here is instituting a narrow, elegant solution to a simple problem. The NDO Fairness Act will insert process and deliberation into gag order requests and make it more likely that Americans whose electronic communications are searched can assert their rights in court. I was proud to join Mr. Fitzgerald in sponsoring this bill, and I thank the chairman for bringing it before the committee. We have passed this legislation previously on a broad bipartisan basis, and I urge my colleagues to do so again today. I yield back the balance of my time.
The gentleman yields back. Before recognizing the gentleman from Wisconsin for a technical amendment, I would just add maybe two things, two thoughts. One, I agree with the ranking member. I think probably every member of this committee that we need to get rid of the payment that was inserted into the continuing resolution. The other thing I would point out is the ranking member talked about, I think he said 8 members of the United States Senate who had their records, their phone records seized by Mr. Smith, or the government or Mr. Smith when Arctic Frost became part of the special counsel's investigation. My guess is it's a lot more. My guess is it's a lot more, because when we deposed one of Jack Smith's top deputies, Mr. Wyndham, he actually told us when we asked him the question, well, actually I say it this way, when we asked him the question, how many other members of Congress did you guys get the phone records on? He took the Fifth Amendment to that. My guess is it's a much bigger number, not to mention the hundreds and hundreds of Americans who were also caught up in Mr. Smith's investigation. Finally, to this bill, this is a good bill. I appreciate the work of the gentleman from Wisconsin, the gentleman from New York. It is a good bill that raises the threshold for when these orders, these gag orders, these non-disclosure orders are actually put in place. And maybe most importantly, and the ranking member mentioned this, it limits the time, 90 days. What we've seen here is years and years of the individual, the American citizen who has his records taken by the government, years they go without knowing that the carrier had in fact given that to the government. And the reason the carrier didn't give it to the government is because the government asked him and the judge said you can't do it. So this is limiting that time significantly. We think that's a good thing. And of course, it has exceptions for children who are exploited in those kind of cases. So this is a good piece of legislation. It's great to see the committee come together on that. Be happy to yield to the ranking member.
Mr. Chairman, thank you so much, and thank you for pointing out that it may have even gone beyond those 8. One of the many problems with the $1 million rider over on the Senate side was, I think, there was a Republican member of the House, I think Mr. Kelly from Pennsylvania, who himself was subjected to the exact same treatment, and they didn't even include him in the bill because he was a member of the House. So I'm happy to represent him in an equal protection lawsuit if they don't repeal this legislation, but I hope they will. And I just want to point out along those lines that this was not the first time it happened, that it had happened under the prior administration with a number of Democratic members of the House who also had their pen records, their phone records surveilled by the government. And I know that happened to our colleague, Ms. Ocasio-Cortez.
And that's the point. This is a separation of powers issue. This is our ability to do our jobs as legislators in the legislative branch of the government. So again, great work here, and I would urge the adoption of and passage of the bill. But first, we got to do a technical amendment. So I recognize the gentleman from Wisconsin.
Mr. Chairman, there's another amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain.
Yeah, Chairman, this amendment just simply corrects what is an error in the bill by rephrasing the language in Section 2, subparagraph B1.
Gentleman yields back.
Mr. Chairman?
I just want to let people take a look at this just so everyone's comfortable. Mr. Goldman? The gentleman from New York is recognized.
I move to strike the last word.
Gentleman's recognized.
I just want to respond to what you were saying about what you were discussing in terms of the phone records. And I think it's really important for the American public to understand what we are talking about. We are not talking about the substance of any communications. We are not talking about the subscriber information of anyone that those lawmakers were talking to. When you are conducting a criminal investigation and you have identified wrongdoing, it is very important to corroborate the story. One important way of doing that is to figure out when people were in communication. Because you may have witnesses saying, oh, this person called that person. And you need to figure out whether that is accurate or not so that you are verifying the information you have. This was not surveillance. This was not real-time wiretapping. This was not a search warrant for any communications. This was part of a broad investigation into a large conspiracy to overturn the 2020 election. Now, I understand that my colleagues on the other side of the aisle take issue with that and think that that was somehow bogus. But if you read the 40-plus page indictment, you will see the exhaustive evidence that the special counsel uncovered about a massive, widespread, multi-pronged effort led by the President of the United States to overturn the election. That is what the grand jury ultimately ratified and voted for. And I am confident that if Donald Trump did not win this election and he went to trial, he would be convicted by a jury of 12. We'll never know because he's President of the United States, so the case was dismissed. But this is not some rogue effort by the Department of Justice to surveil senators or members of the House. And what I would suggest is if people don't want a log of the communications that they have made to be subpoenaed by the Department of Justice, don't engage in crimes. Then you will not have your information taken. But there's nothing here that is done in any way that is outside the scope of any criminal investigation. And if we are now going to say that the Department of Justice cannot investigate any of us, then we are free to engage in as much public corruption as we want, because now they can't get our phone records. They can't see if we are actually communicating with someone who's giving us, like, say, $50,000 of cash in a bag. I think that conduct should be investigated. And I think if I do that, that conduct should be investigated as to me. And so the notion that this was some grand conspiracy to surveil senators and members of the House when it was part of a large investigation that was indicted and charged is preposterous. So stop over-exaggerating what happened. This was not surveillance. This was not some dragnet that's trying to wrap in the members of Congress and senators. This is corroborating evidence to confirm what witnesses said. That is part of any federal investigation. And if you are going to prevent that from lawmakers, you are preventing the Department of Justice from doing its job if we had a normal, traditional Department of Justice that was nonpartisan and that was simply trying to follow the facts and the evidence. That is exactly what you would do, is to get these phone records.
Gentlemen,
yes, I yield to the
well, I want to thank you for that important illumination and clarification here. This is a critical law enforcement tool, and what this legislation does, and I'll let the authors expound if they'd like, is to strike the right balance so it's not being abused. But your point about January 6th, of course, is absolutely right, which is there were hundreds and hundreds, if not thousands of crimes committed that day, from violently assaulting law enforcement officers to trespass into the Capitol to seditious conspiracy, which many people were convicted of. And so it made sense for there to be an investigation. And all this legislation does is to say we need reforms to it from before that time and after that time as well.
Gentleman is back. The gentleman from New York yields. Well, I'll recognize the gentleman from Arizona, and maybe he'll yield some time when he's finished.
Yeah, thank you, Mr. Chairman. I have a question for the sponsor of the bill.
Yes.
Does this bill in any ways prevent law enforcement from looking at members of Congress and their phone records?
No, I think that was kind of the idea, and I think Congressman Adler referred to it earlier. We're just trying to reset the process here. We're certainly not trying to carve out members of Congress. And I understand the circumstances, the J6 stuff is unique, as we just, alluded to what we saw with this current situation where the senators, obviously, their records were reviewed. But no, we're not trying to carve anything out here. I think we're just trying to reset the process.
Thank you. Mr. Chairman, I'll yield to you.
Yeah, I mean, the executive branch can't go to the legislative branch and say, we want all their phone records. We're going to talk about dozens of people, I think, when this is all done. We want all their phone records. And, oh, by the way, carriers, you can't tell them that they have it and have that information for years, and the subject doesn't know it. And all this bill says is, you can do what Mr. Goldman just described, but you got to tell them after 90 days. You can't go years without telling them. That's the outrageous part. So we're saying 90 days, and if it's some kind of investigation somewhere where there's an exception, that's in the bill too. That's what this does. That's why it's a good piece of legislation. I do think it's timely in light of what's happened, what we've learned, and frankly, what the Senate did. But that's what it does, and that's an important check, and that's why I wish this bill would have passed a long time ago. But here we are. Let's pass it.
Will the gentleman yield?
It's Mr.
Yeah, thank you. So I would like it even in a shorter period of time before you have to go back and renew. But I'll live with a 90. But I mean, this applies to everybody. There's no carve out for members of Congress. Right, Mr. Chairman?
Exactly right. All Americans, and maybe you shouldn't have judges just automatically signing these, particularly when you're thinking about members of Congress. That's another issue I think we have to think about. But that's the concern.
Thank you. I'm going to support this bill. I would have preferred that you have to come back more often to get your authorization, your reauthorization, and that you provide the information sooner in a more timely fashion to the American citizen. I mean, we just had a lengthy discussion about that included due process, and it just seems to me like you're invading. And looking at my phone records, I'd sure like to know about it a lot, as soon as I possibly could hear about it, that you're looking at it. So that's the only reason I would say that I wish this would come back sooner instead of 90 days. But with that, Mr. Chairman.
Could the gentleman yield?
Yeah, I'll yield to you.
Thank you. I understand we've actually been passing Mr. Fitzgerald's bill, Mr. Nadler's bill. It's repeatedly rebuffed in the Senate on the grounds that it impinges too much on the law enforcement function. So we're in this great ironic situation where, as a matter of policy, we've been advancing a far more civil libertarian, privacy protective position. The GOP-controlled majority has rejected it repeatedly, and yet when it came to bounce on them, then they decided they wanted the $1 million payout. And I understand that the 90 days, because I agree with the gentleman from Arizona, the 90 days was negotiated up by the Senate. We came in originally with a 30-day proposition.
Back to you, Mr. Chairman.
Yeah. Well,
The gentleman yield?
I find myself in strong agreement with the ranking member.
Mr. Biggs, will you yield for your last minute?
I think he's
I've already yielded to the Chairman.
I'm just going to agree with the ranking member here today, since we're so bipartisan on this bill. The entity that rejected this good legislation that we passed is the very entity that said, oh, but when it happens to us, pay me. So that is the concern. That's why I think this is so timely, so appropriate. Let's pass this. We're going to try to encourage Leader Scalise to put this on the floor ASAP, and we will pass it, which I think is all good. Now I'll yield to the gentleman, and he can yield to the...
Hey, I'll yield to you, Mr. Goldman. But when there's 15 seconds left, I'm taking my time back, so go ahead.
You got it. All I want to say is I support this bill. I think it's a good balance. I was not trying to draw a distinction or in any opposition to this bill. I do think that we need to consider law enforcement functions and the need for secrecy in a law enforcement investigation, but this strikes a good balance and it still allows for that, so I support it. I yield back.
Okay, well, okay. I'll let you go even longer, Mr. Goldman. There you go.
It's because I was agreeing with you.
You are correct, sir. Yeah, Mr. Chairman, yield back to you.
Gentleman yields back. The question occurs on the technical amendment offered by the gentleman from Wisconsin. All those in favor say aye. Aye. Those opposed, no. The amendment is adopted. The question now occurs on the amendment, the amended amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye.
Aye.
Those opposed, nay. The ayes have it. In the opinion of the chair, the ayes have it. Oh, no, we got it. The question now is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the bill is to be reported favorably. The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill is reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up 5713, Expedite Removal of Criminal Aliens Act for purpose of a markup, and move the committee report it favorably to the House. The clerk will report the bill.
H.R. 5713, to authorize the expedited removal of aliens who are criminal.
Without objection, the bill is considered as read and open for amendment. Any point, the chair recognizes the gentleman from Texas, Mr. Gill, for an opening statement.
Thank you, Mr. Chair, and thank you for putting together this hearing today. I want to set the stage for this bill as we get started. Imagine a Trinidad Aragua gang member arrives at the southwest border illegally near the height of the Democrat Biden-Harris border crisis in 2023. He's traveled a long way, but of course he's got taxpayer-funded NGOs who have provided him assistance throughout his entire journey. He's one of hundreds of thousands of illegal aliens encountered at the U.S. southwest border that month and more than 2 million that year alone. Because Border Patrol is overwhelmed, he's released into the interior of the country with a notice to appear in immigration court. To remain in the country and get a work permit, he'll file a bare-bones application for asylum that everybody knows is frivolous and stands no chance of success. Another taxpayer-funded NGO in the U.S. told him to do that, and he files his asylum application anyways. Because the immigration court backlog is nearly 4 million cases, it'll be years before his flimsy case is heard by an immigration judge. In the meantime, he'll move to New York or Chicago or San Francisco, be given taxpayer-funded benefits, be arrested for one crime or another, be coddled by sanctuary city leaders, and defended by Democrats who say America's long-standing immigration laws are simply too mean. Yet he'll remain in the immigration court backlog for years, filing continuance after continuance and motion after motion to delay his eventual removal from the United States. Years later, an immigration judge inevitably denies his frivolous asylum claim. The illegal alien gang member will appeal to the Board of Immigration Appeals, which will then take months, if not years, to reach a decision on his case. Once the Board of Immigration Appeals affirms the immigration judge's obvious decision, the illegal alien gang member will again appeal, this time to a federal court of appeals, which will take even more months, if not years, to deny his appeal. That's the process for one hypothetical illegal alien gang member allowed into the United States. It's not abnormal by any means, due to the open borders Democrat administration years ago. Thousands of federal man-hours at the Department of Justice, the Department of Homeland Security, and in the federal courts have been expended on this case alone, including countless taxpayer dollars. All of this to deny a frivolous claim by an illegal alien gang member to ensure he's deported from the United States. Today, we'll consider a bill to help end this insane nonsense. The Expedited Removal of Criminal Aliens Act is straightforward. It says if you're a criminal alien in the United States, you cannot game our asylum system and you cannot take advantage of the American people's generosity and remain in the country for years waiting for an immigration court hearing. If you're a foreign national who is convicted of certain crimes, you're ineligible for immigration benefits and relief. You must be detained and you must be deported quickly. For decades, current immigration law has authorized a more efficient process to quickly remove certain dangerous criminal aliens from the country. Under existing law, aggravated felon aliens can be removed from the United States without going through traditional immigration court removal proceedings. Current law also makes aliens convicted of aggravated felonies ineligible for immigration relief, such as asylum, and presumes they are deportable from the United States. This process is known as administrative removal or expedited removal. Every federal court of appeals to consider the constitutionality of these expedited procedures have held that the current statute comports with due process. This bill expands the categories of criminal aliens that may be placed in removal proceedings when they are in criminal custody and authorizes DHS to place additional criminal aliens in expedited removal proceedings. The bill allows DHS to fast-track the deportation of aliens who are not lawful permanent residents and, one, are members of a criminal gang, transnational criminal organization, or foreign terrorist organization, or two, have been convicted of dangerous crimes. Democrats, I'm sure, are going to hyperventilate about this bill, but before they do, let's listen to the categories of criminal convictions to which this bill applies. Any felony, any misdemeanor against a member of a vulnerable group, any assault of a law enforcement officer, any sexual offense, any crime of domestic violence, any stalking offense, any crime against children, including sex trafficking of a minor or sexual abuse of a minor, any activity relating to material involving the sexual exploitation of minors, or any violation of a protective order. A vulnerable group in this context includes a child younger than 16, a pregnant woman, an individual with a severe physical or mental disability, and senior citizens over the age of 65. I think, Mr. Chairman, this is a bill that the American people agree with. In fact, a poll from just a few weeks ago showed that 78% of Americans support deporting immigrants who are here illegally and have committed crimes. That includes nearly 70% of Democrats. And those numbers are after a breathless 11-month full court press by Democrats and their far-left media allies to demonize the men and women carrying out federal immigration enforcement every single day. It isn't working. In fact, a clear majority, 56% of Americans, agree with deporting all immigrants who are in the country illegally. Even 36% of Democrats believe that all illegal aliens should be deported. It's no surprise. Let's consider what Democrats did to this country for 4 years. Historic highs of border encounters, with Border Patrol overrun and the southwest border completely abandoned. At least 8 million illegal aliens allowed to enter the United States, including 2 million gotaways who evaded apprehension entirely. Hundreds of aliens on the terrorist watch list encountered at the southwest border, with at least 99 potential terrorists released into the country, and we believe that number is probably significantly higher. That also led to an immigration court backlog that exploded to its highest ever. And the Democrat Party sat by and enabled the border crisis every single step of the way, doing nothing to stop it, in fact, doing everything they could to encourage it. When Democrats controlled and enjoyed unified control of the government with the White House, the House of Representatives, and the Senate, they went out of their way to leave our border open. They did nothing to secure the border, nothing to keep Americans safer, and nothing to enact what they constantly drone about, which is comprehensive immigration reform. So what have they done? Last Congress, the House passed a bill to secure the border and protect Americans. Every House Democrat voted against it. Last Congress, the House passed a bill to kick out foreign nationals who steal Americans' identities and commit Social Security fraud. 155 Democrats voted against it. Just this Congress, the House passed a bill to kick drunk driving illegal aliens out of the country. 160 House Democrats voted against it. Just 2 months ago, we passed a bill to increase prison sentences for illegal aliens convicted of felonies. 197 House Democrats voted against it. In January, we passed the Lake and Riley Act, named in honor of the Georgia nursing student brutally murdered by an illegal alien. 156 House Democrats voted against it. In this committee, in September, we voted out a bill named after Kayla Hamilton, who was killed by an illegal alien. Every committee Democrat voted against it. At that committee markup, Representative Crockett, our friend, referred to Kayla Hamilton as, quote, a random dead person, end quote. Democrats even shut down the federal government just recently to restore taxpayer-funded health care benefits to illegal aliens. This is the Democrats' legacy on immigration, voting against common sense, rejecting reforms, demonizing the victims of their policies. And that's exactly what the American people resoundingly rejected last November. Foreign terrorists released into American communities, gang members unleashed onto American streets, illegal aliens crowded into American schools and hospitals, foreign nationals signed up for voter rolls, illegal alien benefits bankrolled by hardworking American taxpayers. That is their legacy. And at the end of it all, American communities are abandoned, American people victimized, mothers raped, daughters assaulted, sisters murdered, American cities overwhelmed, public services overrun, American generosity overburdened, and taxpayer budgets overstretched. And the American people said simply, we're over it. They gave Congress and the president a mandate to secure the border and fix a flawed immigration system that all too often benefits illegal aliens at the literal expense of American citizens. This bill is a step forward in fulfilling that mandate. Let's chart a new path forward. The Expedited Removal of Criminal Aliens Act moves us closer to that goal, and I urge my colleagues to support it. And I yield back.
The gentleman yields back. The ranking member is now recognized for an opening statement.
Mr. Chairman, thank you very much. You know, the two most beautiful words in the Constitution, maybe in the English language, are due process. It's due process that protects our rights and our freedoms from the arbitrary power of government officers who might be completely convinced of the righteousness of what they're doing, but they might not care about your rights, and they might not care about your freedoms, and they might be wrong about the facts. One of my colleagues said when we got into this debate last time to me, well, wait, you're not saying you support due process for guilty people, are you? And that's the whole point. We don't know if they're guilty until there's been due process. So yes, we've got to have due process for everyone. That's what the Constitution talks about. In our first colloquy about the first bill this morning, Mr. Chairman, we heard members saying that due process was just too excruciatingly prolonged and protracted when we were talking about a case where a guy kicked a dog, spent 3 days in jail, and then was deported from the country. And yet again, we hear from the distinguished gentleman from Texas that due process just takes too long. It just goes on for too long. Look, this bill is a frontal strike on due process. When you think of the government officials who are going to be wielding this lawless power, don't think of the leaders that you love and know the most, the ones who are inviting you to dinner. Think of the ones you loathe and fear the most, because those are the ones you will be empowering also to designate people at whim as terrorists and as drug traffickers. This bill is extraordinary. It would allow the Secretary of Homeland Security to unilaterally declare any of the following people a terrorist or a gang member, even if they've never been convicted of anything, even if they're not being prosecuted for anything right now, and then deport them. Anybody traveling on a tourist visa, anyone working here legally on an H-1B work visa, or an agricultural visa, or a summer work visa, anyone studying at an American university at the undergraduate level or the graduate level can just be designated a terrorist or a drug trafficker without any legal or administrative process at all. The summary designation of people lawfully present here as terrorists or gang members and their removal from the country would take place without any necessary evidentiary proof or any standard at all. This bill destroys due process. It's in plain violation of even the Roberts Court's holding that under the Alien Enemies Act of 1798, persons in America are guaranteed some form of due process before being removed. Yet time and again, we've seen this administration want to designate hundreds of people, thousands of people, en masse, as gang members and terrorists without any concrete, individualized, or relevant evidence to back it up. And these wild accusations have led to devastating consequences. Take the case of Jose Reyes Barrios, a 36-year-old professional soccer player and coach who was an asylum seeker from Venezuela, awaiting his asylum hearing. Unbeknownst to his family, he was swept up and flown out of the country to that famous torture prison in El Salvador as part of the government's dragnet campaign against Tren de Aragua. He had no criminal record. He had no criminal charges, but he was sent to the mercy of a brutal dictator in El Salvador simply because he's got a tattoo on his right arm, which was mistakenly associated with Tren de Aragua. In fact, the tattoo is of a soccer ball topped with a crown, which signifies the soccer club Real Madrid. He had no legal process. He had no judge. He had no jury. He had no right to counsel. He had no opportunity to present evidence or to hear the charges against him. He had no opportunity to cross-examine. He had no due process. Look at one other case, Andre Hernandez Romero, a gay makeup artist and barber who fled Venezuela's brutal Maduro regime, which was persecuting him for being anti-gay and for speaking up for free speech in Venezuela. He'd passed his credible fear interview in our asylum process. His asylum claim was pending when he was swept up in the government's campaign because of his benign tattoos of two crowns, one symbolizing his beloved father, one symbolizing his beloved mother. And that became the basis for his removal with a unilateral administrative power to declare somebody somehow at odds with the government. Romero missed his asylum hearing because he was at the torture prison in Salvador. 60 Minutes reviewed his media posts going back for more than a decade and could not find a shred of evidence linking him to a gang activity, and yet he was described as a gang member. To this day, the government has never brought forward any evidence. He's had no constitutional due process whatsoever. And our friend from Texas wants to make this the law. He wants to make this official that the government can declare anybody a gangbanger or a terrorist without any legal process at all and kick him out of the country. Come on. This is the Judiciary Committee of the United States House of Representatives. How can we be pushing this? And by the way, if you don't care about soccer players and gay barbers from Venezuela, how about this? Are you okay with the Secretary of Homeland Security having a unilateral right to deem far-right white South Afrikaner groups like the Boer Mag, whose leader tried to assassinate Nelson Mandela, designated as terrorists and gangsters, and then simply removed from the country? Is that a power you want to vest unilaterally in a government official? Do you want future administrations to have the right to describe visitors from right-wing groups and parties in Europe, like Alternative for Deutschland in Germany, or Rassemblement National Français, as terrorists and gangsters? This bill is an extremely blunt instrument. It could be used to conduct mass deportations and to strip people here of their rights to due process under the Constitution, as even this Supreme Court has found they have. I hope everybody will join me in my opposition and yield back to this bill, and yield back to you, Mr. Chairman.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The gentleman from Texas is recognized to offer an amendment in the nature of a substitute.
I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Texas to explain the amendment.
This amendment, this amendment amends the relevant statutory sections to which this bill applies, including the mandatory detention statute, expedited removal statute, and withholding of removal statute. The amendment also defines criminal gang, applies the bill's provisions to members of transnational criminal organizations, adds a severability clause, and makes applicable aliens ineligible for all immigration benefits and relief. The amendment makes technical and conforming changes throughout the existing statute. I yield back.
The gentleman yields back. Who seeks recognition?
Mr. Chairman.
Go to Ms. Jayapal. Even though it was a tie on the hands in the air, I'll go with the lady.
She's just keeping me from our CPC meeting.
Okay.
But that's fine.
And me too. Thank you, Mr. Chairman. I rise in strong opposition to this bill, and I think the ranking member laid out the severity of the situation very, very clearly. This bill gives the Secretary of Homeland Security nearly limitless discretion to label any non-citizen as a terrorist or a gang member and subject non-green card holders to a lightning-fast removal proceeding before not an impartial judge, but before a DHS official. And I was just looking at my phone and saw a story of these mass deportations, rapid deportations that are happening, and a story of somebody in New York, a woman who was illegally deported, and they left her 2-year-old child behind. And this was because she was deported in 4 days. All of the process was essentially waived. That is what this administration is doing. They have falsely accused countless innocent people of being gang members and terrorists, and they are using that label as an excuse to ship them off to torture chambers and even killing them. I'm just disgusted that the majority has looked at this abysmal record and decided that what the administration needs is not less power and more oversight, but actually more power to continue to do this. We should be conducting oversight on the Trump administration's abuse of authority and attempts to take over cities across the country in the name of immigration enforcement. Last month in Chicago, I led 18 of my colleagues to conduct the largest act of congressional immigration oversight since Trump took office. And what we heard in Chicago was absolutely devastating. People of all statuses who were terrorized by Border Patrol Commander Gregory Bovino and rogue immigration officials across Chicagoland. And the day after our shadow hearing, Bovino actually deployed tear gas in a residential neighborhood as children were gathering for a Halloween parade. In the words of a federal judge, quote, "These kids, their sense of safety was shattered, and it's going to take a long time for that to come back," end quote. That same weekend, Border Patrol agents dragged a 67-year-old U.S. citizen from his car, breaking 6 of his ribs, while children in Halloween costumes were watching in horror. And you know what? His crime was turning down a street to get home. He never resisted. In another incident, Bovino, the head of CBP, admitted to lying about whether a rock hit him before he deployed tear gas. We also heard from an active duty service member risking his life for his country. His father, he flew back to this country because his father was kidnapped. By the time he got back here, his father had been deported. This is a guy who's serving our country, and he said, how is it possible that I'm giving my life for this country and they're deporting my father who did absolutely nothing wrong? Another 19-year-old U.S. citizen forced to take on her mother's business and care for her younger sibling following her mother's detainment. And folks may remember the militarized raid on an apartment building in the dead of the night that resulted in U.S. citizens, many of them African Americans, dragged out of bed, children, some naked, zip-tied, and detained for hours. And the Trump administration was claiming that this building was, quote, filled with Tren de Aragua gang members and said that they captured 2 confirmed gang members. Stephen Miller claimed that it was, quote, one of the most successful law enforcement operations we've seen in the country. And yet, a month and a half later, Prosecutors have not filed a single criminal charge against anyone who was arrested, nor have they revealed any evidence that showed that anyone actually belonged to a gang. In fact, many of those that were arrested in the raid were granted voluntary departure, and that would not have happened if they were a serious threat. For any federal agents who are watching this, remember that you swore an oath to support and defend the Constitution and the laws of the United States of America against all enemies, foreign and domestic. This conduct that we're seeing does not hold up with that oath, and we are going to hold you accountable. Everyone that is involved in this absolute travesty and violation of justice. And I want to thank Representatives Chuy Garcia and Delia Ramirez, who helped me put this on, as well as Representatives Mary Gay Scanlon, Becca Ballant, Sidney Kamlager-Dove, and Jasmine Crockett for coming to Chicago, along with many other colleagues. This is not normal, and we should be standing up to actually uphold the laws of this country. I urge Republican colleagues to join us and vote no on this. Mr. Chairman, I also seek a unanimous consent.
Gentleman may make her request.
To enter into the record the following articles from ABC. Chicago's children are getting caught in the chaos of immigration crackdowns.
Without objection.
From the Washington Post, suburban Chicago dad headed to store with toddler says they were pepper sprayed by federal agents.
Without objection.
From the Chicago Sun-Times, feds deployed tear gas on the far southeast side even after cops told them they had no gas masks.
Without objection.
From The Guardian, Chicago daycare worker freed from judge rules ICE arrest unlawful.
Without objection.
From The Independent, U.S. citizen 67 has ribs broken by Border Patrol agents after being dragged out of car while driving home into the street they'd blocked off.
Without objection.
From ProPublica, I lost everything. Venezuelans were rounded up in a dramatic midnight raid but never charged with a crime.
Without objection.
From the Chicago Tribune, U.S. citizens racially profiled by immigration agents in Chicago, quote, I felt like a piece of trash.
Without objection.
Thank you, Mr. Chairman. I yield back.
The lady yields back. Gentleman from, excuse me, from Texas is recognized.
Thank you, Mr. Chairman. I'd like to remind the committee that administrative removal is already on the books right now. All this law does is simply expand the categories under which an illegal alien can be deportable via administrative removal. In fact, administrative removal was used 13,000 times by President Obama, over 12,000 times under President Biden. Were those deportations a violation of due process?
Would the gentleman yield?
No, I will not. And if we want to talk about due process, as my colleagues would like to, where was the due process for Rachel Morin, who was slaughtered by an illegal alien? Where was the due process for Kayla Hamilton, who was slaughtered by an illegal alien? What about Laken Riley or Jocelyn Nungary? Where was the due process for them? Where was the outrage when the last administration ushered into our communities Tren de Aragua gang members, MS-13 cartel members, and terrorists from around the world? I think that the American people can see that Democrats reserve their tears for illegal aliens who break our laws and victimize our communities. But if we want to talk about due process, let's talk about due process. Federal courts of appeals have routinely upheld this law's administrative removal procedures as they have existed for the last 30 years. In fact, every federal court of appeals to consider the constitutionality of the expedited removal procedures under Section 238 of the Immigration and Nationality Act has held that the statute comports with due process. Nearly 3 decades ago, the U.S. Court of Appeals for the Fifth Circuit held that, quote, clearly the expedited statutory deportation scheme comports with the minimum requirements of due process pronounced by the Supreme Court. The Fifth Circuit outlined the due process requirements, quote, that an alien be provided notice of the charges against him, a hearing before an executive or administrative tribunal, and a fair opportunity to be heard, end quote, all of which this statute satisfies and did satisfy. As recently as this past July, the Fifth Circuit reiterated that holding, as have the U.S. Courts of Appeals for the 4th, 6th, 9th, 10th, and 11th Circuits. Democrats' fear-mongering contradicts the law, contravenes the text of the bill, and undermines efforts to ensure that dangerous illegal aliens can be quickly removed from the United States. Mr. Chairman, I yield back.
The gentleman from New York is recognized.
Thank you. I move to strike the last word. I'm recognized. Thank you. Thank you, Mr. Chairman. I appreciate some of what my colleague from Texas discussed in his long soliloquy to begin the introduction of this bill. And I agree very wholeheartedly that our asylum system is broken. And I agree very much that it takes far, far too long to adjudicate asylum claims. That was actually corrected in the Senate's bipartisan immigration bill that Senator Lankford and Senator Murphy and Senator Sinema had agreed upon at the very beginning of 2024. Unfortunately, Donald Trump intervened to submarine that bill because he didn't want Joe Biden to get a win. So now my colleagues on the other side of the aisle continue to complain about the asylum system and continue to introduce these expedited removal statutes and bills to account for the fact that asylum processes can take 7-8 years. That bill put it at 6 months. 6 months. And so yet here we are with another bill for expedited removal without any due process. And it almost feels like this is two completely separate bills mixed into one. And I think I know why. Because there are 3 categories of aliens, as it says here, who are subject to expedited removal. First is a member of a criminal gang or a criminal organization, as determined by the Secretary of Homeland Security, not a judge, not an independent adjudicator, the Secretary of Homeland Security. The second is a member of an organization designated as a foreign terrorist organization pursuant to or has provided material support to such an organization. Again, as determined by the Secretary of Homeland Security. The third is someone who's been convicted of a felony or a misdemeanor against a vulnerable group. Well, that is totally different. A conviction, of course, requires due process. So I know where this is going. We, on the Democratic side, are going to oppose this because we've already seen, this is not hypothetical, we've seen the type of people that the Secretary of Homeland, the type of evidence that the Secretary of Homeland Security uses to determine someone to be a member of a gang. Kilmar Abrego Garcia, as we all remember, was whisked away to CICOT in El Salvador, where we now have numerous prisoners who said that they were tortured because he was allegedly a gang member because of tattoos that he had. That, I guess, is how we determine whether someone is a gang member. And so what we're going to hear is, obviously, this is preposterous to allow the Secretary of Homeland Security to make these determinations with full discretion, without any review, without any independent arbiter, to determine whether the evidence meets that. I mean, this is fundamental due process. I know my Republican colleagues would not possibly support Alejandro Mayorkas from making these decisions. There's no possible way. But what we're going to now hear is, the Democrats are against deporting convicted felons against children. That's going to be your talking point. Just like your talking point is still that the shutdown was about providing health care to illegal aliens, when that's been debunked over and over and over again. So if you want to work on our immigration system, you want to fix our asylum system so that we don't have 80% of applicants be denied, but they've been here for 7 years, creating a tremendous pull I am with you. Let's do it. But don't bring expedited removal for someone that the Secretary of Homeland Security alleges and determines on her own is a member of a terrorist organization. Those people should be deported, but they should have due process. And I yield back.
Gentleman yields back. The chair will take the time, but I will yield to the gentleman from Texas.
Thank you, Mr. Chair. I wish Democrats had been as worried about gangs over the last administration as they are about a gang definition in this bill. Because of Democrat policies, Tren de Aragua has an established presence from coast to coast in our country. Nearly every single day, we hear stories about the terror wrought by these heinous criminals. In August, ICE arrested a Tren de Aragua member with an active warrant in Bogota, where he was sentenced to 7 years for trafficking and possessing illegal firearms. He had been caught and released at the border during the Biden-Harris administration. In May, ICE arrested multiple Tren de Aragua members who were involved in a mass shooting at a Chicago house party last December. And these arrests are not limited to Tren de Aragua members. Earlier this year, ICE arrested a gang member from El Salvador with U.S. convictions for sexual indecency with a child, failure to register as a sex offender, illegal reentry, and illegal entry. ICE also arrested an MS-13 gang member with a homicide conviction and a Sureños 13 gang member with 6 convictions for drug possession, 3 convictions for resisting arrest, 2 convictions for domestic violence, and 2 convictions for assault. These are the crimes that are the obvious result of Democrats' open border policies, so today it's no surprise that they'd rather attempt to poke holes in a clear definition rather than own up to their past mistake. The definition of criminal gang here is straightforward. It clearly delineates the requirements to be considered a gang, and it closely tracks another gang definition already in statute, the definition of a criminal street gang in 18 U.S. Code 521. Federal immigration officials shouldn't have to wait for an illegal alien gang member to harm, kill, rape, or terrorize an American citizen before expediting the removal of that dangerous foreign national. This is a common sense provision that creates safer streets for every American and closes a gaping loophole in current law. But if we want to talk about how these determinations are often being made, we hear rhetoric about gang tattoos. Let's look at this gang tattoo here. 666 on the forehead of an illegal alien, Antonio Israel Lazo Quintanilla. I simply do not want an illegal alien with 666 tattooed on his forehead in my country, and I don't think that most Americans would disagree with me there. As we've talked about earlier, this law does comport with due process. There are opportunities for illegal aliens to appeal decisions, deportation decisions, but if Democrats would like to explain why this illegal alien with 666 tattooed on his forehead should be given free rein in the interior of our country, they are welcome to. And with that, Mr. Chair, I yield back.
Gentleman yields back. The gentleman from California is recognized. I yield back on my time. The gentleman from California is recognized.
One day we'll reconcile, Mr. Chairman, the richness of an Ivy League investment banker, Nepo congressman telling us that we need to get rid of the people who pick our food, wash our cars, build our homes, enrich our communities. We'll get to that. But today, this legislation is about making it easier for ICE to remove more of our friends and neighbors. And I guess the question I have is it really that hard for you right now? Is there anything that's getting in your way from just lawlessly going into our communities and detaining American citizens, terrorizing women as masked bandits who are not identified run through the streets, chase people through fields, go into car washes, go to Home Depot parking lots. Like, are you having a difficult time just ripping people away from their families, and you think you need more abilities to do it? Also, quite interesting that you're asking for more legal authorities because you don't even follow the laws that are on the books right now. So what are we doing here, I guess, is my first question. But the American people are telling you, get the hell out of our homes, our streets, and our lives. And I want to play a video, Mr. Chairman, that illustrates that.
I was going to school.
When the spray hit Veraza on the side of his head.
Mama, you okay, Mama? You okay? Are you okay? He's a citizen! He's a citizen!
They do not have a warrant. They forcefully open the door.
No resistance. What am I doing? Kevin! Hey, get on the ground! I love you, let me go! Get back, I will shoot you. You're gonna what? You're gonna shoot me? I'm touching the car, leave me alone! Look what they're doing, sneezing! No.
The American people were promised that the most violent individuals would be removed. And instead, we've been given this. You even deported a child, U.S. citizen, fighting cancer. You deported Miguel Lopez, my constituent, who's been in the country for almost 30 years, worked at a local winery, sent his kids to the high school in my hometown, and he showed up to his immigration proceeding following the law, and he was picked up by ICE and sent to Mexico. And every Sunday night, his wife Rosa and their family look at an empty chair where Miguel used to sit for 30 years with his family. What did we get out of that? Who's better off because Miguel, who was following the law, is not in our community? But earlier this month, the American people from Virginia to New Jersey to Pennsylvania, all the way out to California, sent a message that a reckoning is on its way, that accountability is coming. And this lawlessness that's gone unchecked, a lot's going to change. The masks are going to come off. Officers will identify themselves. And Kristi Noem and Tom Homan, you should familiarize yourself with the four corners of this room. Kristi Noem and Tom Homan, get to know that witness chair. You're going to be parked in it for a long time. You're going to have a lot of questions under oath with the subpoena power. And I hope what you're doing is clean and can withstand the scrutiny that everyone on this side of the aisle is going to bring. You think we won't do it. You think you're invincible. You're wrong. Accountability is coming. You've got about a year, and I yield back.
Gentleman yields back. The committee will stand, we'll come to you when we come back. We're going to have to stand in recess because we have a bill on the floor that Mr. Raskin and I have to manage. And so we will be recess until after that debate, after the vote series, I believe. Then we will be back, and we plan on plowing through as much of this agenda as we possibly can today. So with that, the committee stands in recess.